only I'm mentioning in item 35. Today there's a execution. We have settled. My other side is there. We have settled only for the filing of term, Lordship, recording of term. Lordship, Lordship can keep it tomorrow or day after, as to be mentioned, or any other heading. Only for filing term. My other side is here for recording terms of settlement.
35 Blue View Clinic?
Yes, Bellevue Clinic. Yes.
So day after tomorrow to be mentioned.
May I have my lords kindly to mention a matter, my lord. This is a specially assigned, my lord, probate proceeding, which your lordship was listening, my lord. Your lordship had kept this matter on 16th of September at
Which
3 p.m.
one?
My lord, this is the probate proceeding. It's a specially assigned, my lord. Well, your lordship had kept the matter on 16th of September. My first witness, plaintiff's first witness is complete, my lord. I was supposed to bring my second witness, my lord. My lord, just come to know that he's not in India. He won't be there. He's not in India, my lord. He won't be there for on 16, my lord. I was humbly praying if your lordship takes it up as to be mentioned on any other day, your lordship will keep that part of the proceeding.
To come on 16 September, mention will see to that. 16
I only wanted to not waste judicial time.
Sign leave to mention that's item number 1 and 2 of my lord's non-commercial list. It's for filing written notes. May I file my notes?
1 and 2.
1 and 2 of Lumalas Kama. It's a 12 p.m. matter only for filing notes. My notes are ready. May I file them? I am told my learned friends' notes are not ready.
Fixed on 29. It has come up suddenly today. May I get some time more? Let him file today.
May I file my notes?
We'll file in the next week. So
I'm grateful.
Item number 1 and 2 of the original side list, non-commercial list. Counsel for you are appearing for
the petition for the petitioners in the GAs.
You are for the execute.
Yes, my learned friend is for the execute.
Counsel for the petitioner in GA number 1 of 2025 has and 2 also.
Yes,
both GA number 1 of 2024 and GA number 2 of 2025 has filed this written notes of argument. Let the same be kept in the record. Counsel for the executor prays for time to file written notes of argument. Let the matter. How soon you will file?
Next week,
Let the matter appear on 16 September 2025 as to be mentioned for filing written notes of argument.
In a specific time, like
to be mentioned. To be mentioned. Yes.
I'm great.
Next.
Lordship, may I be allowed to mention a matter undefended suit which was appearing, and it has been allowed by Lordship's order and judgment dated 21st July 2025. Upon carrying on the decree, we came to learn that there is an typographical error or mistake in the cost item.
What is the cost title?
Lordship, the cost title should be
Star
Pipes India, Star Pipes Product within bracket India Private Limited.
And the product India should be in the bracket.
Be in bracket, Lordship.
But what is your
private limited?
What is your an application? Where is your application? Where is the suit? Is the suit or suit?
Lordship, it's a suit. It has been allowed, Lordship.
Suit, what is your cost title?
Lordship, in suit there was Star Pipe Product within bracket India Private Limited.
Okay, so काम करो कल to be mentioned में रखो file लेके correction कर.
Lordship, with your kind leave, may be permitted to mention a recalling application related to a probate matter, your lordship. It's a PLA matter, wherein the caveat of my client has been discharged. It's a purported caveat which my client has not filed, which is reflected from the orders of this honorable court also. So, your lordship, there is some urgency as the main matter is pending before courtroom number 40.
How this court will take?
Recalling application. We have filed a recalling application of your lordship's order by video which your lordship had discharged the caveat of Mr. Sujoy Bhaduri, which is my client. So, it's a recalling application we have preferred, and it shall be taken up.
Recalling application of the order passed by
your lordship.
So what do you want now?
We want a fresh. Our main prayer is a fresh liberty to file a caveat. We are the sole legal heir of the deceased. The will is purported. The will has been revoked, which has been suppressed before this honorable court. It is on such grounds, and so service has not been made. There was an erstwhile advocate who was appointed, who was discharged in presence of the petitioners. Instead of serving the new appointed advocates, they had served the previous erstwhile advocates. So we had no information that a GA had been filed for discharge of the caveat. It is on such grounds, your lordship, that we have preferred a recalling application.
So when is the returnable date?
The returnable date before courtroom number 40 is 16th of September.
That application? No, that is
No, we have filed an
the
fresh.
application which you filed. What returnable date you mentioned in the form? Presentation form?
It was supposed to come on Monday, your lordship.
Monday means
Monday means I think 1 week prior.
16, 15.
15.
15 is a Monday.
No, not 15, the earlier one, the earlier week.
So, okay, let it come after vacation.
But your lordship, if the matter becomes non-contentious, then we will be facing prejudice, your
What
lordship.
can be done?
Your lordship, at least here's a prima facie. If your
I have
lordship-
no time. Before vacation, there is no time. My total diary is packed. Yes, next.
Malad, may I be pleased to mention a matter? Malad, this was a commercial suit. It was filed, it was decreed on 26 January 2024, and I was the defendant number 3 therein.
26 January 2024.
Yes. It was decreed, and I was not.
26 January case was decreed.
Yes. It was the final order was passed on 26th.
Order, GA order. 22nd January 2020.
Okay, 22nd January, my lord. Sorry. My lord, the application for filing the requisites and the order drawing up that was not completed. I was not the plaintiff in the suit. I was the defendant number 3, and the immediate reliefs were not sought against me. So I'm praying for leave to file the requisites and the complete the
Requisites
for the order drawing up.
of the order passed in the suit or in the application?
In the application.
And you are for the defendant.
I am for the
File the
defendant.
wakalatnama.
Yes, my lord.
Wakalatnama and affidavit of competency.
Yes,
So what
my
is the
lord.
difficulty?
My
If
lord,
you file the wakalatama and competency, that you apply in the department will supply the certified copy. What is the difficulty?
the order drawing up was not completed.
Achha, drawing was not completed. कौन सा order है? You have a copy of the order?
Yes.
What is the good name?
My
You
name
are
is
appearing for
Priya.
defend number?
We are applying for defend number 3. We are appearing for.
Here nobody is appearing for the defend number 3.
They are not in the not appeared. They are not appeared.
You are not appearing. On that day you are not appeared.
We had not.
So
appeared.
Now we are appeared.
now you had appeared. We file wakalatnama. Where is how the court can know you file wakalatnama?
We have filed, not yet. Not yet.
We will file, my lord.
But how the court can know? Without the wakalatnama, how on your prayer I can allow the department to draw and complete the order?
My lord, we have already filed the wakalatnama
In the
for the department.
Pata yes. Let the report come, we'll see to that. If it is there, then I'll pass.
Much obliged, my lord.
Yes, anything further? Yes, Mr. Sinha, anything?
I appear to my lord, and I think there's a resolution, my lord. I think will be conveyed.
I
to
don't
your
know,
lordship.
one minute.
Ah.
I mean, it's only for
Number
filing
one.
of the notes, my lord. We have already the arguments are over. Section
Item
34
number one,
application, which was
my
special
lord,
to your lordship.
my lord,
On
I
behalf of the respondent.
the petition, your lordship.
Hmm.
My lord, could we get an extension for a day, my lord? Could we get an extension of time to file the notes for a day, my lord? Tomorrow, my lord, if your lordship kindly permits us to file.
You will file tomorrow? You will file, Mr.
Yes,
Gupta,
my
you
lord, we shall file tomorrow. My lord, it's.
you filed.
I have filed.
You are
I'm
for,
sorry, my lord.
you are for
Yes,
the
yes.
respondent.
Respondent.
Counsel for the respondent file written notes of argument. Let the same be kept with the record. Counsel for the plaintiff prays for a day's accommodation. Let the matter appear tomorrow under the same heading for filing written notes of argument by the petitioner.
Grateful, my lord.
I'm so grateful. I'm so grateful.
Item 1.
My lord, I appear for this stage. Lord, I think, Lord, there's an execution matter, Lord. They've served upon us the copy. Lord, I don't know why it's appearing as to be
Why
mentioned.
to be mentioned?
Lord, this needs to not appear as execution. Lord, it has to appear as an.
Execution case में लगा दो. अच्छा. Let it come tomorrow. Why they mentioned?
Very
Not today.
Other side need to put. Other side need to put.
I appear for the plaintiff, my lord. This is a suit for recovery of money on account of goods sold and delivered, my lord. I'm praying for leave under clause 12, my lord. Everything is within the jurisdiction, my lord. Only the defendant is residing outside the jurisdiction, my lord. I have pleaded in para 32 of my plaint, my lord. We have also gone for mediation, my lord. Mediation has been pleaded in para 28, my lord. It's a non-starter report which is annexed at page 139, my lord. I was only seeking leave under clause 12.
When the cause of action arose,
Now the cause of action arose, my
what
lord.
is the recovery of money?
My lord, yes, my lord.
Decree for recovery of money.
Recovery of money.
When the last payment was made?
My lord, last payment was made in the month of November 2023, my lord. I said page number para 15, my lord. I have pleaded. Annexure L, my lord. Bank statement has been enclosed, my lord.
Defendant number 1 has been admitted in the corporate resolution.
My lord.
Then what is
And
up?
defendant number 5 is the guarantor, my lord,
Ah.
who was making the payment. Even the last payment has been made by the guarantor, my lord.
So you have made the defendant number 1 also as a party?
I have made them, my lord, but
How?
ultimately, because my agreement, contract was with defendant number 1 and the guarantor letter is there, my lord.
But CIRP?
CIRP, defendant 1 has gone to CIRP,
Hmm.
but still the claim is valid, it's there, my lord, which has been paid by the guarantor.
Defendant number 5?
Yes, my lord.
Or the defendant number 1? But the defendant number 1 is under the CIRP.
I understand, my lord.
Then how the suit can be?
But my lord, his name cannot, my lord, defendant number 1 has to be there, my lord. Maybe he is going to CIRP.
Has to be but either you made the resolution professional as a party. Instead of defendant number 1, you make it a request and take the name and made the resolution professional.
Let them come over here, my lord. In the meantime, we
Admission of the plaint when the court you have pleaded here. How the court can? There is a bar. Either you delete the defendant number 1 name or you being made the resolution professional.
my lord,
Make a
kindly
government in
give
that.
me a leave now. I shall correct the plaint. I shall add the resolution professional over there. Represented by its resolution professional, my lord. Because the address would be same. I have to serve it over there only.
Counsel for the plaintiff prays for leave to amend the cause title with respect of the defendant number 1 by mentioning that the defendant number 1 represented through the resolution professional appointed by the National Company Law Tribunal in corporate insolvency resolution process. Leave is granted to correct the cause title with respect to defendant number 1 in course of the day.
In course.
By
Yes,
tomorrow. By tomorrow, after the amendment is carried out, let the matter appear before this court day after tomorrow under the same heading.
Now the deficit court fee, madam, I am carrying it.
And the file in the department, the plaintiff is given liberty to file the deficit court fee in course of the day in the department.
Madam.
Yes.
I am grateful, madam.
Oh, Your Lordship, I appear on behalf of the plaintiff.
Yes.
Suit for recovery of money on account of goods sold and delivered. So plaintiff is within jurisdiction, defendant is outside. So 12A complied with. Non-starter report has been issued on 22nd of May 2025. Lordship will find it at page 71.
Yes.
So I'm only praying for leave under clause 12, which is pleaded in paragraph 18 of my plaint.
What is the suit for?
Lordship, recovery of money on account of goods sold and delivered. I've sold certain trucks. Part payments made. 45 lakhs.
When the last part payment was
The
made?
last part payment kindly takes up page 46. 46 onwards is the ledger. Your Lordship, last page 51, 10th of August 2023. So even from the first date of payment, that is 2nd April 2022, I'm within jurisdiction because my mediation application was filed on 12th of March.
Why clause 12?
Lordship, defendant is outside the jurisdiction.
The plaintiff has filed the present suit, praying for a decree for a sum of rupees 72, 62, 459.25, along with interest at the rate of 18% per annum. Full stop. Counsel for the plaintiff submitted before filing the instant type suit, the plaintiff has initiated pre-institution mediation process, but on 22nd of May 2025, non-starter report has been supplied. Has the defendant failed to come forward to settle the dispute? Counsel for the plaintiff submitted part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of the court, as the defendant is outside the jurisdiction of this court, and prayed for leave under clause 12 of the latest patent 1865. Had the learned counsel for the plaintiff peruse the materials on record, this court find that the defendant is outside jurisdiction of this court and part cause of action arose within the jurisdiction and part cause of action arose outside the jurisdiction of the court. Accordingly, leave under clause 12 of the latest patent is granted. Plaintiff is admitted, subject to scrutiny.
Grateful, Lordship.
Your Lordship, in item number 5, I am appearing for the plaintiff.
Yes.
Your Lordship, this is a suit for recovery of amount for goods sold and delivered, Your Lordship. Plaintiff is within jurisdiction and the defendant is outside jurisdiction, Your Lordship. Therefore, clause 12 leave is prayed for in paragraph 32, Your Lordship.
Yes.
Your Lordship, the payment received by the plaintiff was within the jurisdiction. That is reflected in page 327, Your Lordship. Your Lordship, last date of raising of invoice was on 1st of February 2023, and thereafter a check was issued dated 4th of September 2023, Your Lordship. That is at page 450.
Okay.
And Your Lordship, non-starter report is at page 462.
You have not come forward settlement?
No, Your Lordship.
The plaintiff has filed a suit for a sum of 32,985, along with interest at the rate of 9% per annum. Counsel for the plaintiff submitted. The plaintiff has initiated pre-mediation process before filing of the present suit, but the defendant failed to come forward to settle the issue. Accordingly, not the report has been filed. We further submit that the plaintiff is within the jurisdiction of this court and defendant is outside the jurisdiction of this court, and part cause of action arose within the jurisdiction of this court and part cause of action arose outside the jurisdiction of this court. Accordingly, she prays for leave under clause 12 of the latest patent. 12 of the latest patent. At the learned counsel for the plaintiff peruse the materials on record. This court find that part cause of action arose within. This court find that the plaintiff has already initiated pre-mediation process, but the defendant has not come forward, and accordingly, non-starter report has been filed. The part cause of the plaintiff is within the jurisdiction of this court, and defendant is outside the jurisdiction of this court, and part cause of action arose within the jurisdiction, and part cause of action arose outside the jurisdiction of the court. Considering the above, leave under clause 12 of the latest patent is granted. Plaintiff is admitted subject to scrutiny by the defendant.
Grateful, Your Lordship.
Next.
Lordship, in this also I am appearing for the plaintiff. Lordship, this is a similar suit for recovery for amounts good sold and delivered, Your Lordship. Your Lordship, plaintiff is within jurisdiction in this one as well, and the defendant is outside jurisdiction. The payment was received by the plaintiff within jurisdiction, Your Lordship. That is reflected from page 153. Your Lordship, last date of payment was on 10th of February 2023, and a check was issued by the defendant, which is of dated 13th of April 2024. Your Lordship, the check is reflected at page 178, and last date of payment is reflected from page 172, Your Lordship. Your Lordship, in this, when we applied for mediation, the defendant had replied to the mediation notice, admitting that there are certain dues, Your Lordship. That is reflecting in page 225. Your Lordship, thereafter, a non-starter report was issued by the mediation center, but a revised report had to be issued since the submissions made by the defendant was wrongly reported in the mediation non-starter report. The revised non-starter report is at page 223, Your Lordship.
223.
23, yes, Your Lordship, volume 2. Your Lordship, 223, point number 6, non-starter report reason.
Yes.
Your Lordship, the last line, hence the mediation process ends as a non-starter.
Okay. The plaintiff has filed a petition praying for a degree for a sum of ₹58,082 along with interest at the rate of 18% per annum. Counsel for the plaintiff submitted the plaintiff is within the jurisdiction of this court and the defendant is outside the jurisdiction of this court, and part of the section within the jurisdiction of this court and part of the defendant. To further conduct the plaintiff is initiated pre-institution litigation process. After receipt of the notice, the defendant has not appeared. Subsequently, the defendant could not appear. Subsequently, the matter could not be settled and non-starter report was the plaintiff placed for leave under clause 12 of the latest patent, 1865. At the learned counsel for the plaintiff furnished the materials from the court. This court found that the plaintiff has already initiated pre-mediation process, but the same was submitted as non-starter report, and part was the plaintiff is within jurisdiction of this court and the defendant is outside this court. Also, part cause of action arose within the jurisdiction of this court and part cause of action arose. Considering the above, leave under clause 12 of the latest patent 1865 is granted. Plaintiff admitted subject to scrutiny.
Grateful, Your Lordship.
Item number 10.
Yes.
Lord, item 10, your Lord. I am for the Lord decree holder. Lord, your Lordship was pleased to direct the sheriff to file a report, Lord. Sorry, Lord.
Reply.
This is
Decree
Lord, reply,
to
Lord,
file reply in the meantime.
Lord, here, Lord, the judgment letter was in the box, Lord, and we were, Lord, questioning him, Lord. He was supposed to, Lord, come up with a proposal pursuant to your Lordship's direction, and he was also supposed to file, Lord, the affidavit of assess as well as the affidavit in opposition. He has filed it on the last occasion out of time, Lord, and the Lordship was pleased to give us a liberty to, Lord, file our reply, Lord.
Yeah.
We, Lord, filing our reply, Lord, and Lord, he is not, though his presence is not dispensed with, he is not there in court today. Lord, no proposal till date, evading. We understand that he has, Lord, sufficient, Lord, assets to, Lord, satisfy the decree, Lord, but then, Lord, he is concealing facts. Lordship, Lord, keeps it tomorrow or, Lord.
The decree holder has filed a reply Affidavit in reply, let the same be kept with the record, as none appears on behalf of the judgment debtor. For the interest of justice, case adjourned, let the matter appear on 11 September.
Your Lordship, may kindly, my lord, provide that the judgment debtor should be present before your Lordship, my lord.
September. Let them come. If they're not,
But
it
it's
is
not
made
been
clear that
dispensed
on
with, my lord. He's not here today, my lord.
so it is made clear that on the said date, if the judgment debtor failed to appear in
The
court,
conduct is extremely mischievous, my lord.
appropriate order will be passed. Next.
Grateful.
My lord, in this matter, there was a injunction restraining the judgment debtor from dealing with the assets, and also there was a direction to file the affidavit of assets. The affidavit of assets have been filed. The affidavit of assets has already been filed, my lord. And there was an examination of the judgment debtor also, and in course of the examination of the judgment debtor, the judgment debtor's the director who was representing the company, he had undertaken to pay off the outstanding dues in certain installments, of which he had paid some amount, but the major portion is still outstanding. My lord, if your lordship sees the affidavit of assets which have been filed, it would go to show that the judgment debtor has the means to pay, as would appear from the affidavit of assets. And there was a specific undertaking to pay off the balance amount of 43,61,505 in 6 monthly.
Who is appearing for the judgment debtor?
My lord.
Because today nobody is appearing. Bar resolution is there. No order can be passed.
Lordship gives it for tomorrow.
Day after tomorrow?
No, day after tomorrow, I'm in difficulty, my lord. So then Lordship will make it not this week, because from Wednesday to Friday, I'm in personal difficulty. I have to go somewhere. So Lordship will kindly keep it tomorrow, because I've been waiting for this matter for quite a long time. Lordship.
Counsel for the decree order is present. None appears on behalf of the judgment debtor. Let the matter appear tomorrow.
Okay.
Next.
Well, this is my
Item number 11. I am praying for not today. After vacation.
You are appearing for?
The petitioner.
Item number 12.
11.
11 is already not today.
Yes.
Not okay.
Yeah.
Yes. Item number 12.
13 to 12 হবে এবার।
Not today.
My lord, I am for the decree holder, my lord. Here, my lord, your lordship recalls, my lord, lordship, my lord, had directed the deputy sheriff, my lord, to file a report, my lord, stating, my lord, a warrant of arrest was issued, my lord, on an address wherein no report was filed by the sheriff whether the warrant was executed or not, my lord. Your lordship had, my lord, sought for a report from the your lordship takes, you know, the order dated 5th August, my lord, paragraph 3. In view of the above, the Deputy Sheriff of Calcutta is directed to submit the report whether the warrant issued against the judgment debtor at the address mentioned above, which is appearing at paragraph 1, my lord, is served upon the Superintendent of Police as well as the officer in charge of the concerned police station for execution, and whether any report has been submitted by the concerned
when the warrant was issued?
My lord, the warrant was issued
2nd May.
Yes, my lord. I should. Well, there were 2 warrant of arrest, my lord. The first one, my lord, the address was, my lord, wrong.
So first, second address is D1 to Vijayanagar, Hanuman Nagar.
Yes, my lord.
That's
yes.
the second one.
Yes, my lord. Residing at D21, Vijayanagar, Hanuman Nagar, Kankarabad, Patna 20. This is the correct address.
Correct. That was issued on 5th of May.
Yes, my lord.
Correct.
Yes.
So
So,
it was-
a report pursuant to that, my lord, has
Now it has come.
It has come.
विषय में समय सदन सूचित किया जाता है कि अभियुक्त नवनीत वास्ता ए पार्टनर ऑफ अपराजिता एंटरप्राइजेस एट D21 के पते पर खोजबीन किया गया। उस पते पर नवनीत वास्ता नाम का कोई व्यक्ति वर्तमान में नहीं रहता है, अतः बिना तामील करे वापस किया जाता है। श्रीमान से सादर सूर्य प्रणाम।
Unfortunately, my lord, they are there. He's very much there, my lord. We had sent, my lord, representatives. He was found there.
But there is a report. On the basis of the report, the Sarif has submitted the report. The person is not available. There is no person residing in the name Navneet Vasa at the address. So
It's becoming a stalemate situation, my lord. My lord, may I, my lord, only pray this, my lord. In that event, my lord, Lordship may, my lord, direct the report to be circulated to me, my lord. I shall again, my lord, take necessary steps. Lordship keeps it after, my lord, vacation. I shall, my lord, find out in the meantime.
in terms of the order dated 5th August 2025, the Deputy Sheriff of Calcutta has submitted the report along with the report submitted by Police Authority, Patna. Let the report be supplied to the Learned Counsel for the decree holder by tomorrow. Within a week. एक कब सब सफाई कौन करेगा? क्या बोला? The department. Let the be supplied to the within a week. Police staff. List the matter. And the petition director to take appropriate steps within a week thereafter. List the matter. On 23rd September 2020.
Well, will it be a lordship's pleasure to keep it after vacation, my lord? Because we shall, my lord, in the meantime also find out, my lord. Lordship, kindly keep
Within
it
a week, take appropriate steps within 2 weeks. List the matter on.
We'll also take some time, my lord, in finding out the.
4th November.
I'm grateful. I'm extremely grateful.
Yes, next.
Item number 14, Your Lordship, this is my execution application.
Yes.
Lordship, this is a decree against Your Lordship, the state of Madhya Pradesh, where Your Lordship was pleased to direct them.
But any appeal is pending?
Appeal has been dismissed, Your Lordship. They preferred an appeal. They preferred an appeal that is dismissed. They
Against
preferred
the order. Which order the appeal was preferred?
Your Lordship, this order passed by Your Lordships regarding Your Lordship the appointment of receiver and Your Lordship locking of that particular office. The Honorable Court, Your Lordship, found that the receiver has already complied with the order and that nothing subsists. Thereafter, if they file a review application, the review application, Your Lordship, has also been withdrawn with the liberty to file an Order 9 Rule 13, but till date, Your Lordship, no Order 9 Rule 13 application has been filed.
So now the
situation here, Your Lordship, is I would like to press for Your Lordship the sale of the assets. But
that is the only way.
Yes, yes. Report has been also been filed by Your
Lordship. The report.
Yes, Your Lordship. Report has been filed by the receiver.
What is the total amount?
The total amount, Your Lordship, on the execution application is 1,15,54,232. And 10% interest, your lordship, is recurring.
So two officers have been attached.
Yes, your lordship.
Divisional Forest Officer and Chief Conservator of Forest.
Yes.
Okay. Yes.
Only one thing, your lordship. Before passing the sale order, your lordship, lordship will give the another chance, your lordship, for filing of affidavit of assets, because I have two options. GA2, your lordship, is in connection with the filing of affidavit of assets. In disobedience, your lordship, the principal secretary will personally. That's one way. And the second way is the sale. What I am praying, your lordship knows, your lordship, this resolution. Otherwise, your lordship, they'll again take the same. Tomorrow, forward us, if your lordship kindly speak.
Come tomorrow.
Otherwise, the matter, if lordship will go down, your lordship, then again, I'll not get the chance.
None counsel for the decree holder present. None appears on behalf of the judgment debtor due to the resolution of the bar. Case is adjourned. Let the matter appear tomorrow under the heading orders. Yes.
But 15, I am for the decree holder, my lord. I am for the decree holder, my lord. Judgment debtor has to take instruction from the client to pay in installments. We are not.
Not today.
Not today, man.
Not today. Next.
But I am appearing on behalf of the decree holder. On the last occasion, my lord, in this execution proceedings, your lordship was pleased to direct the judgment debtor to give effect to some rectification. Lordship will kindly see your lordship's last order. This is the matter where your lordship, my lord, had passed an order as to how the jurat portion of an affidavit should be affirmed.
Yes.
The order
But unfortunately, my lord, the affidavit which I have been served does not contain the jurat portion which your lordship rectified in this matter. And there are also, my lord, other discrepancies. And I must point out that this is the third time that the decree holder is given an opportunity to rectify mistakes in the affidavit of assets. My lord will kindly have a look at my lord's last order.
May I file the affidavit? Item
Have you
number?
served?
Yes.
Yes.
This is item number. The first one is 511.
511. 16.
Yes, the 511. This
Yes.
is the copy to the.
By this time, my lord, can kindly see your lordship's last order, page 4. Lordship, my lord, has directed as to how the jurat portion could be, especially, my lord, point number 3 and point number 1. Statements contained in paragraphs blank to blank are derived from records. Then the statements made in paragraphs blank to blank are true to the best of my knowledge and belief, and the rest are submissions. And point number 3 is very crucial. I have not suppressed any facts, and statements made by me are true and correct. Now, my lord, kindly see the affidavit of asset which has been filed today.
Where is this one?
Yes,
Yes, I think I have filed. Which is affirmed on 14th of
yes, this is the one.
August.
My lord will kindly come to the jurat portion which is at page 6.
Where is the last portion?
So, my lord, now, my lord, may I
Okay,
make
am
this
not
submission?
suppressed. 11 is there.
Now, I feel the last portion has not been given because of certain things. My lord will kindly have a look at paragraph number 5. Here, my lord, the deponent says that he is a partner of a partnership firm. So, my lord, his income should reflect, paragraph 6, his income should reflect the capital which is lying with the partnership firm.
Correct.
Because the capital is an asset of the partner. The capital may be a liability of the firm, but it is definitely an asset of the partner. These are, my lord, on screen, prima facie problems in this affidavit and doesn't require any examination. Now, my lord, that is not there in paragraph 6. What is more glaring, my lord, unfortunately?
Paragraph, which paragraph you are referring?
Paragraph 5, your lordship will see.
I am engaged in the business of construction and the name is so and so.
Yes. I am a partner.
I am also the director, also a director of itna.
So, my lord, he says I am a partner. So, if he is a partner, my lord, he has capital which is there with the partnership firm. That must have been reflected, my lord, somewhere in this affidavit as his income. At paragraph 6, he doesn't mention that.
Okay.
This is a prima facie defect. Now, my lord will kindly have a look at paragraph number 9. Yes. Paragraph number 9 at internal page 5. Here, your lordship will find following are the debts which are due. Now, my lord, these are names given. But what is necessary for us to know to give effect to a garnishee proceeding is the place where these people are located, the address of the usual place of business.
Okay, Mr. Banerjee.
I can ask these questions. But if I ask these questions, then what your lordship required them to do, that is the statement, I have not suppressed anything. It's not there.
No, it is there.
No, I have not suppressed any.
Yes. I have not suppressed any facts and statement made by me or to.
That is paragraph 11.
11.
So, my lord, if this is so, then paragraph number 9, the description is not there. my lord, it was argued on behalf of the my lord, judgment debtor that his assets are not within the jurisdiction of this honorable court. So if that is so, then these are, my lord, paragraph 9 and paragraph 10, the debts and liabilities. Where are these people located are something, my lord, which is very essential. My lord, I do not wish to examine anybody. From the document I find that they are outside, I will definitely proceed elsewhere.
Mr. Banerjee, it is a procedure to file the affidavit of assets by the judgment debtor.
My lord.
Correct. The court has not having any knowledge whether the affidavit declared by or filed by the judgment debtor is correct or not. It is only an affidavit.
Yes.
So if you are disputing that, then it is up to the decree holder to prove this is not correct. And for
Through
that,
examination.
through examination or through other way to produce the document. This document, this is the asset which he has not declared. So this affidavit, this is up to you. So if he has filed the affidavit, you serve the copy. If you want to examine the judgment debtor. If you want to, you will not cross-examine and you want to argue the matter on merit, then the court will.
What I was on is, the Lordship is aware this Rahul S. Shah's judgment, paragraph 42.17. Kindly have a look.
Correct.
It's will pardon me. It is marked and 42.12.
Yes.
There is a mandate of 6 months in a commercial dispute. This has been followed in 2025 by Supreme Court.
Correct.
But I am not on this 6 months. I know it may not be practically possible. The Punjab Haryana High Court, the Honorable High Court judge has suspended a judicial officer for not following this procedure. Be that as it may. What I was actually on, if I find from the affidavit that this person indeed does not have any asset in the High Court of Calcutta, I will proceed elsewhere.
Correct.
Because it is not correct for me to waste
if he has not
judicial
disclosed, if you are not disclosed, either you get the details, and file
impossible for me to get the details of the name of the debtors and the liable people against whom liability.
You get the details, not the debtor and other details of the property which the judgment debtor is having. Or otherwise, because this is original side, you get the benefit on that.
Yes.
All the things is to be brought by the judgment debtor. You need not to, the decree holder need not to do anything. But you will go to the district judiciary.
Reverse.
It is reverse. It is up to the decree holder
to do.
That is the property of the judgment debtor. If it is not, you have to clear follow all the procedure. If you found yes, there is no property at all which can be satisfied the decree, then you have to pray for the civil prison. And that civil prison also, the cost is to be bear by the decree holder.
Yes.
That to 3 months.
Correct. So here the you persons are getting in the original side order. It's the affidavit of assets.
Benefit is there. I was only on expeditious
Correct.
disposal of this.
Expeditious. That's why I am. If you want to examine the judgment debtor on the basis, I am fixing a date for. If you are telling that no, you will argue the matter on merit, then I will.
No, there is nothing left to argue in an execution.
Correct.
It's only realization of the funds because they have not even preferred an appeal. May I beseech your Lordship, if it is possible, anytime this side of the vacation, because practically one person will come. This is the execution. I would not have.
No, why one person will come? There are 3 persons, 3 affidavits are here, Miller.
But in 2 matters, we can proceed.
The judgment debtor has filed affidavit of assets after serving the copy to the London Council for the.
Can pass common orders in 3 matters.
Decree holder.
Yes. I'll just file the other asset.
The record. Council for the decree holder submit that the judgment debtor has not filed the affidavit of assets in its true spirit, and as such, you want to examine the judgment debtor. In view of the submission made by the council for the decree holder, let the matter appear on 16 September at 3 p.m. for examination of the judgment.
Well, it's 16. 16th, I'm not in Calcutta. I'm sorry, Miller. In 16, 15, 17, 18, 16 Bombay. No, 15, 16, 17th, 18th.
I would not have pressed this, but
in one execution case, when I was practicing in the district judiciary, I have pressed totally the revenue department and all these things. I could not find anything. The shop which was running, it was in the rented portion. He left that also. so that I cannot. What can be done then? Nothing. The 3 months imprisonment. When the pass an order, file an application, the court has issued the order, and automatically money came.
Yeah, okay.
No, these issues can be resolved as well. I'm sure that
End is a settlement. That is a settlement. End is a settlement.
23rd September at 3:45.
345.
इस तरह सबका
23rd
कर दो.
September. ठीक है. 345.
All you file the affidavit.
No, I will be filing, my lord.
16 and 17.
Yes, I'll
15,
just
16, 17.
512. Just because
No, 15, 16.
50, 16, 17, 20.
16, 17,
20.
and 20.
One of the item 17 is EC 512.
512.
512. There are 4 affidavits.
Okay.
In EC 512.
Okay.
ये चारटे.
Item number 20. Just a moment. Item number 20 te tum cost data bhula cha.
No, it is now 16, 17 is taken out.
Yes, and 17 similar order can be passed. It is only in item number 20 that there are 3 judgment debtors.
17-4.
EC com 505.
He's telling us 17-4. 17-4 judgment debtor.
EC com 8 টা কোথায় তাহলে?
Sorry, Mulad. 17 there are 4, but there is a typographical error in the cost title in one of the affidavit of assets. I was just trying to indicate that.
হাত উল্টালে কোত্থেকে হবে ভাই?
Which one?
That is item number 20.
Yeah, no, 17.
17 is fine.
17 is fine. There are 4 affidavits.
Yes, Mulad.
Yes, 17 there are 4 affidavits.
17 में ना खाली लिखो judgment debtors have filed 4 affidavits, 4 separate affidavits of assets.
505 নম্বর ছিল এরকম কিছু একটা?
না,
বাকি সব
ভুল করেছি।
একটু ভুল করেছি।
এইটা।
And what about the 20?
20 নীলকণ্ঠ. This is only against নীলকণ্ঠ.
Yes.
But the only difficulty lordship will have to give me a leave to
20 Mulad, there is a mistake in the cost title. Lordship will
the number has gone down as 505. It will be, I mean, 8. It had
505 of the suit.
No, EC number is EC com 8 of 2025. It has gone by mistake. The typographical mistake has gone in as 505.
So CS,
it is only a typographical error, Miller.
CS টা ঠিক আছে.
And CS is also wrong. CS is not
CS is
96.
So that
96.
name of the party is correct.
No, Malad, it is CS 505.
CS.
Malad, I'll आगे affidavit টা दाओ.
CS ये क्या है?
आगे affidavit টা.
CS number क्या है? आप
CS is 505.
505.
हाँ,
So you are
505 of
mentioning
2024.
96 you have mentioned.
हाँ, ওটা ভুল হয়ে. There's a mistake. That's the mistake. এইটা
Item
আগের
number
affidavit
20.
ছিল.
The judgment debtor has filed affidavit
এটাই
of
হবে
assets,
নিশ্চয়ই.
but the learned counsel for the judgment debtor submits that in the cost title, the number of the EC com is wrongly, inadvertently typed as EC com number 505/2024 instead of EC com number 8 of 2025. Simultaneously, the CS number is also wrongly written as typed as 96 of 2023 instead of CS com 505/2024. In view of the submission made by the counsel for the judgment debtor, the judgment debtor is granted leave to correct the EC number and CS number in the cost title of the affidavit of assets affirmed on 14th August 2025 in course of the day. বাকি হইছে না? Correct it now, correct it.
Correct it না, এখনই করে দিই. এইটা তো?
Yes, next.
এইটা. Only
I'm deeply obliged, Mulad.
Deeply obliged.
Then on the correction. Not today. 18 not today.
Item 19.
Not today.
Item 21.
21, my lord, I am for the terms of the last order passed by your lordship, my lord, they are paying installment. They have paid for first installment, my lord. Well, let this matter appear after vacation because second installment is due on 22nd of this
September.
month. 22nd of this month. Let this matter appear after vacation, my lord.
Counsel for the judgment debtor, decree holder submit that the judgment debtor is paying the decretal amount installment and as such he prays for fixing the matter after the vacation. In view of the submission made by the counsel for the decree holder, Let the matter appear on 6th November.
Great.
21.
21.
21 though.
21.
22.
The 22, I beg to appear for the petitioner.
All
Your
done.
Lordship,
Yes.
22, my lord, I am for the petitioner, my lord. Your Lordship may recall, my lord, this is for, my lord, seeking occupation charges of the property occupied by the defendant. Now, my lord, in this matter, your Lordship had directed the defendant to make payment of the occupation charges. From where, my lord, the defendant preferred an appeal. Appeal was dismissed with cost, my lord. And, my lord, lastly, your Lordship had directed for affidavit of assets to be filed on 11 June, which has been filed. Thereafter, my lord, the your Lordships had last fixed it on for examination of the debtor. Thereafter, my lord, matter could not be taken up. Today it has come up before
Examination of judgment debtor.
the debtor judgment debtor, my lord, has to be examined.
Yes.
I believe today no one is appearing as expected, my lord.
So what you want?
My lord, may kindly fix a, my lord, date for examination of the debtor. My lord, last, my lord, 21st of July, Lordship had fixed on 26th of August. That day, my lord, the Honorable Court was not sitting. Therefore, my lord, it has come up today.
Correct. Now, what is your prayer, sir?
My lord, my lord, may kindly fix it for examination of the debtor, my lord, once again.
By an order dated 21st of July 2025, this had fixed the matter on 26th of August 2025 at 3 p.m. for examination of the judgment debtor. But due to non-ability of the court on the date fixed, the examination could not be conducted. Accordingly, London Council for the degree holder raised for fixing another date for examination of the judgment debtor. In view of the submission made by the council for the degree holder, let the matter give the date for examination judgment debtor. November at 3 p.m.
Great production.
The decree holder is directed to inform the date to the London Council appearing for the judgment debtor.
We shall.
Yes, next.
23, my lord, I appear for the decree holder again, my lord. In this case, my lord, we have served upon the judgment debtor. My lord, this is for the balance amount. My lord, a portion of the amount was, my lord, satisfied through the deposit which was made. And, my lord, the balance amount is outstanding as of today. My lord, your lordships had passed an order, my lord. The debtor has never appeared before, your lordships.
So have you served the copy?
Yes, my lord. On 30th of July, affidavit of service has been filed. Even earlier, my lord, in June, we had filed an affidavit.
None appeal council for the decree submitted. Not fit. So what do you want? They are not appearing.
My lord, that's the difficulty, my lord. If your lordships may, my lord, either today I can't pray for an arrest, my lord, or
not today.
Not today. Very well. Great.
Next.
24, my lord, I am for the decree holder, my lord.
Lordship, appear for the police authorities. We have served a notice of on the
Authority, what execution case?
My lord, your lordship on the last occasion, my lord, had directed me, my lord, to directed, my lord, a notice to be served upon the judgment debtor through the officer in charge, my lord, Jorabagan PS, my lord.
That has been done.
That has been done, and the report, my lord, I am here to see, my lord.
I've served.
The copy has not been served to him.
No.
But yes, copy, yes. At page 3 of the report, you are served with the notice.
My lord.
Okay.
Surprisingly, my lord, he had been contesting an appeal, my lord, using the address, my lord, mentioned in the cost.
Now he's given the new
Now
address.
he has given the address, my lord.
EC 93 sector 1.
Yes.
I am only praying, my lord, since it's moving ex parte, my lord, your lordship may kindly, my lord, issue a warrant of arrest on him, my lord.
Today I am not.
What I'll do, in the course of the day, I'll serve a copy of this to him. So let him proceed. On
then in that event, my lord, may I do this, my lord? Subject to your what falls from your lordship. Lordship, may kindly give me a direction, my lord. I shall serve a copy of the application again on the new address. Yes. And my lord, there was an
Today
interim order.
I am passing an order to supply the copy in the one you take appropriate steps in terms of the refund.
And your lordship may direct me to serve a copy on the new address, my lord. And there is an interim order.
Necessary. Yes, it has been served by the police authority.
My lord, I had served the notice, my lord. The application, my lord, I had not
served.
Application, my lordship told me to serve a notice, my lord. So I had, and the order I have also served.
What's the good name, sir?
Arindam Mandal.
Arindam
Mandal.
Mr. Arindam Mandal, an advocate appearing for the police authority, and submit the report wherein it reveals that the judgment debtor has appeared in the before the officer in charge Jora Bagan PS, wherein the judgment debtor has informed his present address as ECE capital C capital dash 193, sector 1, ground floor, Salt Lake, PS Bidan Nagar within bracket south, pin 7009090. It is also found that the notice was also served upon the judgment debtor. Let the report be kept with the record. The Mr. Mandal is directed to serve the copy of the report to London Council for the decree holder in course of the day.
Your Lordship, yes.
In course of the day.
And my presence may be distanced with any further.
Yes, yes. As from the report, it reveals that the judgment debtor is residing in a new address. Accordingly, the decree holder is directed to serve the copy of the application along with the documents to the judgment debtor in the new address as mentioned in the report. Within a week from date?
Yes, sir.
Within a week from date, full stop. Let the matter appear on 23rd of September 2025. The Mr. Mandal has already filed the report. He has been discharged from the instant case as appearing on behalf of the state.
The interim order, my lord, is already there, my lord.
Please continue.
My lord, I shall, my lord, just.
Where is the interim order?
My lord, 31st July, my lord, was the interim order. It is other orders. My lord, it is at 31st July, my lord.
Till the disposal of the present activity.
Grateful, my lord.
Yes, next.
25, my lord, I am for the decree holder, my lord. They have to take instruction for payment, my lord. Make it not today.
Not today.
26 again, my lord.
22.
My lord, I beg to appear on behalf of the decree holder. My lord, your lordship's decree. My lord, this is my execution. My lord, they have filed an application saying it's premature because your lordship was kind enough to grant them installments at a lower rate. My lord, not even one installment paid. Last day, my lord, they handed up a check of rupees 2 lakhs. My lord, this is the position, my lord.
What has happened? 2 lakhs in cash or dishonor?
My lord, 2 lakhs encashed.
2 lakhs
Cash.
Yes.
So what do you want now?
My lord, I would be
made not today and let them
my lord, I'll be praying for filing of affidavit of assets on the next day.
Not today. Let take
Very,
not today.
Great.
I appear for the decree holder.
Yes.
Lordship, this is a judgment dated 28th June 2024. The execution application is appearing for the first time, my lord. Lordship, this is within period less than 1 year, Lordship, we have filed. Lordship, today I'm asking for only
new one.
New, my lord. A prayer for, we have ascertained only the properties.
Money decree.
Money decree. I'm sorry, my lord. This is the judgment which is at page 119. The operative portion is at 129. The decree is of for principal sum of 84 lakhs. At 129, Lordship will find the operative
84
portion.
along with interest 18%.
Lordship.
From 2022 till realization not paid.
No, my lord. It has not
paid.
been paid. Lordship,
28
that is why, my lord, in paragraph 26 and 27, Lordship, I have been able to ascertain, Lordship, only one bank account and one property. Lordship, I am praying for injunction on that. And Lordship, on direction on them to
file their.
That an amount is there.
Lord, we do not know. We do not. Whatever is there, my lord. Lordship may injunct.
Where is the prayer?
Lordship, there's a prayer.
Regular statement.
Lordship, prayer C, my lord.
Injunction restraining judgment of dealing with. Decree holder has filed the present execution proceeding for execution of the judgment and decree passed by this court dated 28 June 2024, wherein this court directed the defendant to pay an amount of rupees 84,23,539.74 along with interest at the rate of 18% per annum with effect from 15th February 2022 till realization of the settlement. Counsel for the decree holder submit that in spite of the decree passed by this court, the judgment debtor failed to pay the amount and accordingly filed the present document. He further submit that during the inquiry, the plaintiff and the decree holder came to know that the judgment debtor is maintaining an account at Gurgaon.
Lordship.
Maintaining an account at Axis Bank, Gurgaon branch, being account number 915020002781902902 and the judgment debtor is having the property being plot number C-5/7/3 at measuring 9152 square meter along with industrial shed having constructed area of 1866.60 square meter from MIDC capital, MIDC Shendra SHENDRA 5-star, industrial area situated within village limits of Sendraban SHENDRABN Sendraban, Aurangabad Municipal Corporation rural area within the limits of Talika and district Aurangabad. Okay. Counsel for the plaintiff submit that and decree holder submit that in spite of the decree passed by this court, the judgment debtor failed to pay the amount and as such he pray for interim order restraining the decree holder from dealing with the landed property as mentioned above and also to dealing with the and also to restrain operating the above bank account without keeping aside the decretal amount along with the interest as on date. At the landed counsel for the decree holder peruse the materials on record. This court find that by a judgment and decree dated 18th of June 2024, this court passed the decree directing defendant to pay the aforesaid decretal amount along with the interest, but in spite of the same, the defendant failed to pay the same, due to which the plaintiff and the decree holder compelled to file the present execution proceeding. In view of the above, the judgment debtor is restrained from operating the bank account maintaining the Axis Bank Gurgaon branch being account number 91502000278192 without maintaining the amount of rupees 84, 23, 539.74 along with interest at the rate of 18% per annum with effect from February 2022 till today. and also restrained from dealing with the property as mentioned above till the disposal of the present execution proceeding. Full stop. The plaintiff is and the decree holder is directed to issue notice upon the judgment debtor returnable by this local no Delhi returnable by 4th November 2025. This is the matter on 24th.
I'm grateful. Or you may also direct them to file their affidavit of assets.
The decree on the judgment debtor. The judgment debtor is also given liberty to file the affidavit of asset on the returnable date.
Grateful.
Yes.
My lord, item number 28, I am for the decree holder, my lord. On the last occasion, lordship directed to serve notice upon the judgment debtor through the learned court below, that is by the learned district judge Barashat. My lord, that was served. It was served. Report we have received that the notice along with the above cited relevant document has duly been served upon the judgment debtor, my lord. And we have also sent, but that was not delivered. May I file the affidavit of service as well as the report we have received from the department, my lord. There is an order of injunction lordship has passed on the last occasion.
What about the district judge report?
It was report. Report. I have kindly come to the bottom portion of the report. As per the report, the notice along with the above cited relevant documents has duly been served upon the judgment debtor Mahadev Patra.
Who is the judgment debtor? Mahadev Patra?
Mahadev Patra is the sole judgment debtor.
Okay, not today.
My lord, kindly fix it tomorrow for under the heading forward. Otherwise, it will go down, my lord.
And
let the affidavit of service be kept in the record, my lord.
Holder has filed the affidavit of service. Let the same be kept in the record. The Deputy Sheriff of Calcutta has filed the report wherein it reveals that the notice along with the relevant document has been duly served upon the judgment debtor, namely Mahadev Patra, on 21st of August 2025 at 1 p.m. At this address mentioned in the notice, and the judgment debtor Mahadev Patra received the said notice by endorsing his signature and date on the sheet of the service report. Let the report filed by the secretary be kept in the record. As full stop. Let the matter appear tomorrow under the heading orders.
Grateful, lordship.
तो इसको दे दो. Next. Not today.
My lord, this is the case where the judgment debtor evaded to appear before the court, and they filed to GA for dismissal of our court, our matter. And for them, that was not, the honorable court was pleased to give them opportunity by submitting the 1 crore 60 lakh, what was the principal amount. They did not pay even a single paisa. Then again, second time, they were given opportunity to pay at least 70 lakhs rupees. That was also not done. They are not in the matter, in the interest of they are not paying, going to pay this. My lord, and this execution should be filed against them. So the execution petition has been filed against them. And I have prayed in this execution.
What is the money decree?
Yes, my lord, money decree.
Okay, so they are not appeared. Notice served.
Yes, what he took this original paper from me here.
No, whether notice served upon the execution notice was served upon the judgment debtor.
My lord, this was not served.
Not.
Not directly served. Not served.
So serve the copy.
I will serve the copy.
Hmm.
This time I will, because the address was not, he was not available on the address.
So serve the copy.
And now this he has given, in this copy, he has given his own address, now the change address. That is at tabular statement number 10, Jarda Bagan, Jangra Sri Krishna apartment. He's temporarily shifted from his own original place and has gone there. So, and not a single copy could be served to him.
Okay, serve the copy.
Again, I will serve the copy.
The decree holder is directed to serve the copy of the application along the documents of the execution proceeding to the judgment debtor at the address mentioned. Where it is mentioned?
It is mentioned here.
Which document you are referring?
I am my documents are here.
Where the address you are mentioning? Where from you are referring?
Yes, I am here. Tabular statement number 4. Number 10.
Page number?
Tabular statement number 10.
Tabular statement number 10.
Yes. And E.
कहाँ में है? हाँ प्रदीप कुमार बैनर्जी हाउस ऑफ कलकत्ता
New address has been given.
E.
E.
To serve the notice upon the judgment debtor at the address being premises mentioned being premises number 134/B, block G, New Alipur Police Station, New Alipur, Kolkata 700053, and also at Sri Krishna apartment, flat number G2, J15/1, Zarda Zarda Bagan, Jangra JYANGRA Jangra, PO Jangra, PS Bahuati, Kolkata 700059. Within 2 weeks from date. Please the matter on 6th of November 2025. 6th November 2025. The judgment debtor is directed to file the affidavit of assets on the date fixed. Next.
I appear for the decree holder, my lord. The last order, my lord, passed by your lordship was on 28th of July 2025. An order of, my lord, injunction was passed in addition to the previous order passed on 23rd of June 2025. Now, my lord, on 23rd June, lordship had passed order in terms of prayers A, B, and C of the tabular statement.
Yes.
My lord, kindly takes prayer C of the tabular statement once, because I would be seeking for one additional direction today in terms of this.
What has happened to the judgment debtor? Where is the judgment?
My lord, they are not. Lordship remembers the suit was also, my lord, heard lordship in this matter. Well, I was seeking for one direction to serve the bank, the manager of the bank, the order of attachment, so that, my lord, because I have sought for transfer of the fund, whatever is there, my lord.
So, my lord, kindly permits me to, my lord, serve the manager of the bank, my lord, concerned bank.
For what?
My lord, this order of your lordship, for them to comply with the order. Otherwise, they may not have knowledge. And without, my lord, a specific, I have served, my lord, but there has to be a direction of service on the judgment debtor. But on the bank, my lord, I need a specific direction.
So ABC sees the order passed directing manager or the concerned officer where the judgment debtors maintain the account.
But
C
my
is there.
yes, but my lord, kindly sees lordship's order of my lord 23rd of June, my lord. There, the specific direction of service was on the judgment debtor.
Judgment debtor counsel for the prince submission instrument. Considering ABC are allowed until further orders.
Yes.
C is covering.
Then, my lord, 7. The decree holder is directed to serve notice along with this order to the judgment debtor. And judgment debtor is directed to file affidavit of assets. My lord, there was no specific direction to serve bank, my lord. I don't. Whether bank would comply with it or not.
Learned counsel for the decree holder had all the attention of this court to the order passed by this court dated 23rd June 2025 and 28th of July 2025. By an order dated 23rd of June 2025, this court passed an interim order in terms of prayer A, B, and C of the tabular statement. Tabular statement. Full stop. Counsel for the decree holder submitted, though this court passed interim order in terms of prayer A, B, and C, but there is no direction upon the decree holder to serve this order to the bank, that is to the manager of the concerned bank. Which bank?
My lord, Indian Overseas Bank, my lord.
The concerned bank.
That's the only bank we know of.
That is the Indian. But you have not mentioned the manager of.
My lord, I have given in the affidavit, my lord, it's written, paragraph 12 of the, my lord, affidavit in support of the tabular statement. Indian Overseas Bank bearing account number ends with 5705.
21.
My lord, para 12, my lord, at page 8 of the affidavit. And also sees, my lord, para 13, my lord, after 12.
To the bank. And
since it is
manager,
linked with
Indian
PAN cards.
Bank. Which bank? Which area? Which branch?
My lord, this was the only information available to us. Account number is there and PAN card, my lord, it's linked with PAN card. I'll serve, my lord. That's my
Indian Overseas Bank
job to serve the
having account number 0585 0585 होगा 02 4 1 2 3 4 5 times 0 0 0 0 0 5 times 0 5705.
Or any other bank where, my lord, this PAN card is linked.
Full stop. Connected with the PAN card numbers AAPCS 0312 capital R, comma AAMCS 7941P, comma AHWPG 6495J, comma and ABUFS 7512C. In view of the submission made by the counsel for the decree holder, the decree holder is given liberty to communicate the order dated 23rd June 2025 to the
affidavit of service
25 as well as 28 July 2025 along with this order to the manager Indian Overseas Bank for
my lord, one additional direction. My lord, they have, despite your lordship's last, my lord, order, they have not filed the affidavit of assets. Today, because of the resolution, I am not asking for warrant, but kindly, my lord, record that if they choose not to file it, I would be
Let they come on it.
But I filed the affidavit of service, my lord, today.
Affidavit of service filed by the decree holder be kept with the record. Let the matter appear on 4th November. Next.
For the decree holder, my lord. This is decree, my lord, is passed by your lordship, my lord. On the last occasion, my lord, your lordship was, my lord, pleased to direct the judgment debtor, my lord, to file affidavit of assets, my lord. My lord, I had, my lord, while moving the execution application, my lord, I had served on 3 addresses of the judgment debtor, my lord. My lord, thereafter, they did not appear on the last occasion. Your lordship, my lord, directed me to serve again, my lord, the order, as well as, my lord, and an order was also passed directing the judgment debtor to file affidavit of assets, my lord. I served at the same address. Now, my lord, interestingly, it has come back as left. They took the service first on the first occasion. It served both the affidavit of assets, both the affidavit of service, my lord, is there, my lord. Lordship may kindly it to Joshua. Lordship may kindly take, my lord, the affidavit of asset, my lord, affidavit of service, my lord, dated 16th July, my lord. That's the previous one, my lord. It shows, my lord, that page 6, my lord. Affidavit of service dated 16th of July.
Item delivered.
Item delivered addressee. The same address, my lord, be again served pursuant to your lordship's direction. My lord, lordship takes the other affidavit, my lord. It says, my lord, no such person at page 7. Same address, my lord.
Yes.
They are evading service, my lord. I'm only, my lord, praying, my lord, lordship may kindly, my lord, issue warrant of arrest, my lord. Otherwise, they will not come. Decree almost, my lord, of 2 crores. They're purposely doing this, my lord. They are very much there. But the details of the, my lord, principal officers, my lord, are at page 14, my lord, para 38. I'm not subject to correction, my lord. This one of the principal officer who's the whole time director, she had deposed, my lord.
Three judgment debtors or one?
One, my lord. 3 addresses, my lord. I had
So 3 addresses.
whatever address I got, my lord, I served.
This is the one address with
This is, my lord, yes, my lord. The
what
one.
about the others?
No, others have, my lord, the envelope, my lord, they've come back left. It is not there.
All.
Out of 3, my lord, 2 has come back, my lord, as unserved on the first occasion only, my lord. The only address which was is the registered address. That was served.
Last occasion you have given filed
On the same address which was served.
It was served to only one.
Yes, my lord, only one address. My lord, first time I served on 3 addresses. And the second time I served on only one address, which was the correct address.
What about the other 2 addresses?
My lord, my lord, it says
first report.
First report, my lord, my lord, the envelopes have come back with the endorsements left. No such person. I have not attempted to serve on these addresses on the second time, my lord. The second time I served only on the address which was received. My lord,
But you are not mentioning the affidavit 2 has written unserved. In the first affidavit, which you mentioned on 16th of July.
Well, that time, my lord, it did not come back, my lord. After filing of the, my lord, affidavit of service, my lord, these envelopes we have received.
But you are also not mentioned with regard to whether these are come back or not, taking report or not.
That if your lordship directs me, I'll file a supplementary, my lord, affidavit. My lord, but then, my lord, the address which has been served, my lord, is there. If your lordship takes, my lord, 16 July affidavit of service, my lord, page 6, item delivered addressee. It is this address, my lord. It is the registered address, office at 211 Okla Industrial Estate.
So that's why this is with regard to the one address you have sent. Now this first, the today which you have filed the affidavit.
Yes,
what
my
about the 2 address you have sent?
My lord, on the second occasion when your lordship directed me to serve, I only sent it to one address, my lord, because this says left. That is the reason, my lord, I did not send it there, my lord.
The first notice which was served, in which address it was served?
It was served on, my lord, 211, Okla Industrial Estate, South Delhi, New Delhi, 20. That was the address. That is the registered address, my lord. Registered office address.
That is the first address.
That is the first address, and it was served on that address. If your lordship takes, my lord, the postal receipt also, my lord, at page 5. If your lordship sees the number, my lord.
2712 812.
Look, before that, if your lordship takes, my lord, page 6 once, my lord, I shall show the service, my lord. If your lordship takes the number, my lord, it's EW271. Lordship got it?
Yes, yes.
EW271255812IN.
Number 1.
Number 1, my lord.
Number 1.
If your lordship takes page 5.
It is 211.
The 211 has been served, my lord. Right. So on the second time, I only served on that address, my lord. Now it says left. No such person, my lord.
And what about the second 2 address?
Left. They're purposely doing this, my lord. Purposely. They had initially contested, then they left in between.
Decree holder has filed the affidavit of service. Let the same be kept. It is found that on earlier occasion, the decree holder has sent the notice upon the judgment debtor on 3 addresses. With regard to one address, the notice was delivered, and in two address it was written unserved with the notice no such form. No such form in comma. Okay. Subsequently, as per the order passed by this court, the plaintiff and the decree holder has again sent the press notice upon the judgment debtor.
Along with your lordship's order, my lord.
Judgment debtor at the address
211 Okla Industrial Estate.
211, Okla Industrial Estate, South Delhi, New Delhi, -110020. But the same was returned with the endorsement, no such furtherance. This court find that on the earlier occasion on the same address, the notice was served upon the judgment debtor, but second time it was mentioned that no such person is available. Considering the above, this court find that on the first occasion, the notice was already served upon the judgment debtor at the address mentioned above, but in spite of receipt of the notice, none appears on behalf of the judgment debtor. Accordingly, this court has no other option but to issue warrant against the judgment debtors or debtor. Against the judgment debtors.
Judgment debtor, my lord.
Debtor.
Only
debtor, one. The plaintiff and the decree holder is directed to take appropriate steps to file requisites in the department for issuance of warrant against the judgment debtor within a week from date, returnable by 6th November 2020.
Or whenever, my lord, they are produced, my lord. My lord, and the details, my lord, of the persons involved are at page, my lord, 14, paragraph 38.
Notice. Yes, next.
I'm so grateful, my lord.
Yes.
No, my lord, the item number 33, my lord's order and decree arose out of order 13, order 37A application is put to execution, my lord. But it's on the first occasion, my lord, I am only, my lord, besides, my lord, asking for the affidavit of assets, my lord, by the judgment debtor, my lord, being apprehensive of their conduct, my lord.
Move.
Yes, my lord.
So what you want? Notice is to be served?
My lord, no, my lord, obviously, my lord, the apprehension, by virtue of the apprehension, my lord, that I have canvassed in my paragraph 11 and 12, my lord, and the decretal amount is around of 50 lakhs, my lord. And for that, my lord, I am only asking for, my lord, prayer, my lord, of your lordship, my lord, tabular statement, my lord, C, D, and H.
Where is the decree?
My lordship will find, my lord, at page decree, page tabolo. Handwritten one. Lordship will find the order at page 37, my lord.
30 lakhs.
Yes, 30 lakhs plus, my lord, total, my lord, 40,
principal along with the interest.
along with, my lord, 48 lakhs, 48 lakhs, 38,000, my lord. And along with further 13% interest till the final realization, my
So
lord.
now what you want now?
But I am asking for, my lord, C and prayer, C and the injunction and attachment, my lord. But I have given the list of movables and immovables, my lord.
Where is the property? Where
My
is
the
the
property
prayer?
schedule A, my lord, lordship will find at page after the tabular statement, my lord will find at page 2. Bottom, my lord, I have given the chart, my lord, description of the property, my lord, out of which, my lord, A, B, C, D, E, F, G, and my lord, W and X, those are all within the periphery of West Bengal, my lord, and out of which, my lord, in original jurisdiction, my lord, there are already the properties of B and E. Lordship will find, my lord, at Park Street, Little Russell Street, 5 Russell Street, Park Street. Both are, my lord, both are the showrooms, my lord. And, my lord, those are within the original jurisdiction, my lord.
B and
E, my lord.
So these are the showrooms.
Yes, my lord.
So what injunction you will get from the showrooms?
No,
Not to
and
sell,
my lord,
not
my
to
lord, I am
sell.
seeking for no, my lord, I am seeking for the attachment, my lord, and my lord, there are others, my lord, movers, lordship.
Attachment at this stage, how it can be?
My lord, B, my lord, are the schedule B are the movable properties, my lord, out of which, my lord, I am asking for the receiver, my lord, because there is a apprehension, my lord, and which is reasonable as I have canvassed in, my lord, paragraph 11 of my petition, my lord, they will take away with, my lord, everything, my lord.
Where is the property? This all the things. Where is the property? I bank guarantee, bank amount, bank or any lender property. The court can pass
And
an
my lord,
order.
besides that,
Straight.
my lord, I have also requested.
Regard to the attachment, then the process.
Then my lord, kindly direct my lord. I have given my lord the prayer B is also there, my lord. My lord, prayer C is also there, my lord. Kindly see. Prayer C, my lord, kindly direct them, my lord, their bank account, my lord, to be operated.
That's why I'm asking. Where is the bank account?
My lord,
where is the details?
My account detail, my lord, I couldn't give, my lord, but there are. But kindly see prayer C, my lord, once, my lord.
I have seen. Where is the bank account details?
My lord, an order and a direction be passed for attachment of the bank accounts mentioned.
Attachment can't be at this
Kindly
stage.
see, my lord, it is linked to it, but I've given the PAN number.
Maybe you show me the bank account, I will pass an order. You show me the landed property, I will pass an order restraining for dealing with. But
there are land.
I will not pass any order for attachment. Sorry. Let the affidavit of asset be filed.
Malad, I have enough disclosed. I have enough malad, properties I have has been disclosed in the petition, malad.
So that's why I'm telling. What injunction can be passed with regard to the showroom?
But not only there are other landed properties also, malad.
Show me. That's why I'm asking. Where is the landed property? Show me. Show me which landed property.
Well, those are I must say outside, malad. But those are the landed properties. Malad, kindly come to malad of the schedule A, malad. Even malad start with the A1, and that is the landed property, malad. It is a flat, probably Suruchi Bihar, Taliganj Circular Road, New Alipur. This is a flat. This is a immovable property. There are others also, malad.
Okay,
and we have all derived from the balance sheet, malad.
Okay, you should notice. Let them come.
Malad, kindly, malad, some protection.
There's so many property they will not dispose of. Let them
At least, malad, in respect of one property, malad.
Which property? You tell me.
Malad, kindly in the schedule A, malad, A property, malad. That is not a flat, malad. That is within the vicinity, malad, of the Taliganj Circular Road, malad, New Alipur.
Bungalow.
Yes, malad. In respect of only one property, malad, that property, malad, kindly give, malad. Bank account definitely I will come with, malad.
Where is the decree?
My
The
decree, malad.
plaintiff has filed the present
and
execution proceeding for execution of the judgment
immediately after the
by
schedule.
this court. Passed by this court.
Bank account
dated 25th of June 2025, wherein this court directed the defendant to pay the principal amount of rupees 30 lakhs 330,00,000 along with interest at the rate of 10% per annum from 19 June 2019 till realization of the decree. Counsel for the decree holder submit that in spite of the decree passed by this court, the judgment debtor paid the principal amount, not the interest awarded by this court. And that's it. The plaintiff has filed, the decree holder has filed the present execution proceeding. Counsel for the plaintiff has, the decree holder has disclosed several immovable several movable and immovable properties in the schedule A and B of the present execution proceeding and prayed for an injunction with respect of the property situated at Suruchi Vihar, I-47, Toliganj Circular Road, Block capital N, Bungalow, New Alipur, Calcutta, 70053. Consider the submission made by the counsel for the plaintiff. This court find that this court has passed a decree directing the defendant to pay the principal amount of rupees 30 lakh along with the interest at the rate of 10% per annum from 19 June 2019 till the said amount. But in spite of the decree passed by this court, till date the judgment debtor has not paid the decretal amount along with interest. Concerning this court find that the plaintiff has made out a prima facie case and balance of convenience and inconvenience in favor of the decree holder. At this stage, interim order is not passed, the decree holder suffer irreparable loss and injury. Accordingly, the defendants, their men, agents, servants are restrained from dealing with the property, namely Suruchi Biharoi Walapma, till the disposal of the present execution proceeding. The plaintiff is directed and the decree only directed to serve the copy of the notice of the execution proceeding along with the documents to the judgment debtors and the judgment within a period of 2 weeks from date. Police of the judgment debtors are directed to file their affidavit of assets on the returnable date. Let the matter appear on 6th November 2025.
My lord will only consider prayer E of my tabular statement. But kindly consider one.
30 lakh is enough. Bungalow is enough. Yes. Call the fixed matter.
And my lord already directed the affidavit of assets to disclose. Grateful.
Item number 3 and 4 kahan ka? Commercial. Yes.
Fixed matter, my lord, in view of the resolution Mr. Bachawat was addressing your lordship, my lord, he hasn't come to court today.
Okay. It is fixed tomorrow also?
Yes, my lord, it's fixed.
It's fixed tomorrow.
Let the matter appear tomorrow.
I'm good.
Next.
34, my lord, I beg to appear for the decree holder.
Let there be direction to serve me a copy, my lord, of the execution.
Service has been effected, but
My
then
lord,
again, I'll again do that.
My
Not
lord, it was
only
served
one
to my bank,
indulgence. Yes. Lord, may I file the affidavit service? I'll again serve. Lord, there is no difficulty on that.
My lord, this is an execution of a dismissed matter.
Only one thing. Lord, a correction.
Execution in the dismissed matter.
Yes,
a correction will be required. A correction is required, my lord, in the tabular statement. I tell your lordship, lord, what is the crux of my lord kindly comes to page.
I don't have the copy.
No, kindly comes to page, my lord, 47. That's the operative portion of the my lord, decree.
47 of the?
My application, my lord, the affidavit in connection with the tabular statement, my lord.
Yes.
Page 47, para 16.
Yes.
The plaintiff company is granted liberty to withdraw the amount deposited along with accrued interest with the bank pursuant to the order of this court dated such and such, passed in such and such. Lord, this kindly come to Lord page 15. This is Lord the fixed deposit that I want to encash pursuant to the decree. This is what the execution is all about. Lord, unfortunately, Lord, the tabular statement your lordship would find, Lord, the assistance column, Lord, that has incorrectly, Lord, kindly permits me leave, Lord. And I shall serve the corrected copy on my learned friend.
My lord, I file an opposition, my lord. That is not the correct thing which my learned friend is proposing.
That is what is there.
My lord, that will come on the merits of the next
That is all right. Not I.
But you have to come with an application. Amendment of the
amendment application. Good. Amendment.
Counsel for the decree holder prays for time for taking appropriate application for amendment in the tabular statement. Accordingly, time is granted. Let the application be filed within 2 weeks.
2 weeks.
After serving the copy to the London Council for the decree holder judgment debtor.
Amendment application.
Judgment debtor is liberty to file affidavit in reply within a week thereafter. List the matter.
Lordship may give me 2 weeks because my client is based in Hyderabad.
2 weeks. List the matter on 13th November.
Obliged. 13th November.
Next.
I am for the decree holder. My lord, here there is adjustment of the decree and Order 21 Rule 2.
I appeal for the judgment debtor, your lordship.
I think this is more question. Page 150.
Item number?
35.
35.
35 करें. दोनों
Yes.
पति है तो करने.
But since we are here, my lord.
My lord, in item number 36, my lord, I am appealing for the dependent.
No, my lord, I appear in item 35. 35 is called.
Both the parties are there, then let it be completed.
My prayers, lordship, see, are for recording satisfaction of the decree by an agreement. That is my tabular statement prayer. I would have thought this was by master summons, but then this is the procedure. Prayer A,
adjustment and satisfaction of the decree.
prayer B is a discharge of receivers. Prayer C, there's a name change. Well, for two of the judgment debtors, 5 and 6 have merged in number 1. And number 1's name has been changed from Arch Realtors to Bhumia Realty. That is prayer C and D.
Yes.
And the agreement by which the parties have agreed to adjust and settle the decree is at page 158. So we want this to be recorded. Oh, sorry, 150. 150. Prayer A. Prayer, which is prayer A. This is signed by all the. Well, we were to get some portion in a property under the decree.
Yes.
Bellevue as the occupant was to, under the decree, was to get a portion of the property, but we will take money instead. So this is page 150. This is the settlement that was reached.
That we have paid, the judgment debtors have.
So will full satisfaction in terms of the agreement.
Full satisfaction. And page 167 is the name change certificate given by the registrar of companies. Change of name. That is Mr. Rupak Kush's client.
Because the agreement is actually signed by the current, in the current nomenclature of my clients. So that's why page 167 is very important.
Where is the decree?
The decree that the drawn up decree is at page 6.
That was also by settlement, page 6 at page 7 was the settlement. Page 6 is the decree. Page actually, it starts earlier. Page 6 is the date. Or 7 is the date.
Terms of settlement.
7 is the date, 18th of December, 2017. The terms কিন্তু থাকে এখন নতুন করে শুরু করেছে ডিগ্রিটা somewhere.
So before filing before filing of this execution, you settle the dispute.
Yes, we have settled but after the decree, but then this is a post-decree settlement. We didn't file any execution application. We were settled, so we want to have the settlement recorded. So that's why I was saying this should have been by master summons, but departmentally we were told to go for. I was a little surprised.
That's interesting.
Why an execution at all?
Yes. This is what the department had. In fact, when I settled the draft, it should be by master summons. Anyway.
And what is the date of the agreement?
The agreement date is, that's prayer mentioned.
July 25. Yes. And you file this execution proceedings August 25.
Yes.
Immediately thereafter. The holder can file any time.
How that's
yes, my tabular statement should not be. I agree with you fully. I was myself, but they said departmentally they want tabular statement. It should be master summons. But then this is the nomenclature computer, anything concerning execution, it is easy.
Has to be a tabular statement.
Formatted. This should have been master summons. Chamber application.
The decree holder file the present execution proceeding for execution of the decree dated 18th of December 2017. But it is Learned counsel appearing for Mr. Learned counsel appearing for the decree holder submit that though the parties have settled their dispute in terms of the prayer in the tabular statement by entering into the agreement dated 22nd of July 2025, which is annexed with this application at page being annexer B, page 149 to
That is at page 148.
149 to 166.
Yes, yes, yes.
166. And thereafter, the name of the company has been changed from ARCS Capital, Realtors Private Limited Subcapital to Bhomea, BHO, page 167.
Well, that's subject to correction. The name has changed before. That's why
I recorded. I have
no,
recorded.
before this agreement for
Before
settlement.
this
Yes,
agreement.
yes.
Okay.
This is
That's why
2024.
Bhumia, that's why the terms record Bhumias.
December 24. After the decree, but before.
Yes, before the
Annexer B, full stop. It is further submitted that before the agreement is entered between the parties, comma, the name of the company has been changed from ARCH Realtors Private Limited to Bhomia, BHOMIYA Realty Private Limited on what is the date? Full stop. Subsequently, the company ARC Realtor Private Limited is incorporated under the Companies Act, and that the company is limited company. Fully. Considering the above, this court find that the decree passed by this court dated 18th of December 2017 has been fully satisfied by entering into the agreement as well as by changing the name of the companies. Thus, there is nothing remains in the execution proceeding. Accordingly, EC Com 505 of 2025 is disposed of.
Affidavit of service on record.
Affidavit of service filed by the decree holder be kept with the record.
My lord, in item number 36, my lord, I am appearing for the applicant defendant, my lord. My lord, the suit has been dismissed for default, my lord, in which, my lord, a bank guarantee of 50 lakhs has been deposited as per the on court's order, my lord, with the bank, and it has been renewed from time to time, my lord. My lord, on dismissal of the suit, my lord, my GA 10 of 2024, my lord, 2025, my lord, is only for seeking liberty to withdraw the bank guarantee. And my lord, there is no application for restoration of the suit has still now been received from our end, my lord.
Who are you? You are.
Well, I am the defendant applicant, my lord. I am the defendant in the suit. The suit has been dismissed for default, my lord. And my lord, there is an order at page 10, my lord, of GA 10.
Yes. None person according to the John. Given much acknowledgement of the suit is dismissed for default.
Yes, my lord. And my lord, already 1 year and half, 1.5 years has already passed, my lord. No intimation of any application has been received, my lord, from our end, my lord.
Okay. Have you served the copy to this?
Yes, my lord. Yes, yes, my lord. Yes, my lord.
Where is the affidavit of service? Where is the affidavit of service?
The master summons and the court all are filed, my lord.
That's the only postal receipt. Where is the track report? There's only the speed post receipt is there. There is no track report to show that this notice has been served. Find the track report, come on the next day.
My lord, track report is there, my lord.
Where is that?
My lord, in the master summons, my lord.
Yes,
Affidavit of service,
the receipts is there, sir.
my lord, there have affidavit of service has been filed, my lord,
This is the
with the
affidavit.
department.
Okay,
My lord,
yeah. This is, yeah.
in page 3, my lord, the postal track report has been annexed. It has been delivered on 19th of July 2025.
This court is not having that track report, sir.
Then, my lord, kindly adjourn the matter for next week, my lord, so that I can on next Monday, my lord, or tomorrow, my lord, whatever your lordship. So,
Okay, not today, come tomorrow with the track report.
my lord, I'm grateful, lords.
Next.
I'll go to the
Item 37, Your Lordship, I am for the defendant. I've just taken out an application in the nature of subpoena, Your Lordship, for the calling, Your Lordship, the witness, Your Lordship, from the
Scientist B.
Yes, Your Lordship.
PFSL Kolkata.
CFS
Yes.
Kolkata.
Yes.
My lord, there are two issues, my lord, I would like to highlight. But this is my suit. I want the suit to be heard out. It is not a contentious issue, but my lord, in terms of the case management hearing order 15A, rule 2B, my lord, there is a list of witnesses which was required to be produced.
Yeah.
That was indicated, Your Lordship. We have given, Your Lordship, the officers of the CFS.
My lord, the name
We have
of the
indicated, Your Lordship, in the list of witness as officers of the CFS.
there was one already summons passed. There is a now they have come up with a second person, and I'm only praying that if there is any other person or any other application, it should be indicated, because
That's why.
officers is a very vague.
That's why. In the original side, the case management, discovery inspection issues. Thereafter, it will directly go to the case management. There is no provision in the list of witnesses.
There's no, but my lord, here list of witnesses were produced. The parties had given, and my lord, it was corrected, and this was the indication. I'm only praying.
What you want to show?
No, my lord, initially it was indicated to us that there will be only.
This was from the CFS.
My lord, may kindly grant leave, my lord. She's aware of the factual scenario.
Your Lordship, if Your Lordship has a look at takes up the CFSL report, which is essentially a report that they are trying to rely upon. Serial number 5 states that if evidence is required for spot visit, because 4 is done, spot visit correspondence please may be made with A. Bandopadhyay. Mr. A. Bandopadhyay was one of the members who had visited the spot, and the spot inspection was conducted. My learned senior friend has come up with a subpoena application where they are wanting scientist B, Mr. Kallol Sil, to come and lead evidence. We neither do have any objection, nor is there any scope for any objection, Your Lordship. The only little point that we are trying to bring to your notice is that if evidence is required to be given of Mr. A. Bandopadhyay, tomorrow my learned senior friends should not again come and say that there is a fourth witness, because they have already once exceeded the number of witnesses.
Examined?
No, A. Bandopadhyay has not been examined. Only in serial number 4, Mr. Baijanta Mukhopadhyay, he has been examined. Yes, that was examined, and that was over. Now, for the spot verification, instead of Mr. A. Bandopadhyay, they are bringing Kallol Sil. Your Lordship, that should be their last witness. That's it. They should clarify that.
Lordship, if I show Your Lordship, there's a report, Your Lordship, which is required to be proved, where A. Bandopadhyay has made his signature, and there are other members, Kallol Sil, Subhashish Mukherjee, and Sotip Patro.
Correct.
So one person can come and prove the entire thing.
But see, this CFSL authorities,
Yes.
why they are giving this name? Because he is the main person who is deal with the report, and the other persons were along with the persons site inspection and investigation and all these things. They are signing as a co-scientist, but the main tomorrow I don't know what will be
Your Lordship has exactly understood the point. Your Lordship, humbly praying, nothing else is our contention. That is the exact point which we are praying, because it's my
officials. These are government officials. Now, what happened when we call Baijanti Mukhopadhyay?
The whole issue is that today one person is authorized. If another person is brought in,
it's my defense. If they control the entire defense, kindly appreciate my
They
situation.
are what they're telling that
I understood. I understood it.
If
Now,
you restrict only to this Kalolsil, they have no objection. Tomorrow you should not come with the, again you want to Bandopad.
what happens, Your Lordship? We called Your Lordship Baijanti Mukhopadhyay, Your Lordship, who was the person. Now, he said during the cross-examination or the time of examination in chief that he can only prove a part of the report. Now, again, we have to take that Kollol Shil is here in Calcutta right now. We can call him and he can do the entirety. So we are
If the
calling.
Kallol will say no, this, then what will happen?
So he is already signatory. I don't
signatory, but maybe
irrespective of the fact,
because
my lord,
every
we'll
time
kindly
it's
see.
a CFSL, we cannot enter. Now, what happens? We approach Your Lordship, one of the officers, and who has tell Your Lordship the Kollol seal is the person who can adduce the evidence in entirety. I think Your Lordship, he'll come and.
So can I record? You will not examine Mr. Bandopadhyay because they are raising
I
objection.
don't know, Lordship, if he comes and says something during
That's
the
what I'm telling,
examination.
because as per the report, because you are relying upon this report.
Yes, sir.
And you wanted to prove this report through Mr. Kallol seal.
Then can I request one thing, Your Lordship? Kindly give me 5 minutes time. May just call the advocate on record and clarify.
No problem.
Because if I say something, that
Correct.
will be
You take, because the report says something, and if you examine tomorrow, then again it will be, and if you will able to give the statement that yes, you will not examine the Bandopadhyay, whatever the evidence of the Kallol seal, you will relying on that.
It's only 5 minutes, Your Lordship, pass over. I'm just calling it.
Pass over. Next.
Yes,
I'm opposing these two applications, my lord.
I'm for the dependent number 1, my lord. DS7 was filed by us, my lord, to grant the seek of your lordship to file the written statement against the counterclaim filed by the dependent number 3, my lord.
You are for the plaintiff.
I'm for the dependent number 1.
You are for the defendant number 1. Yes. So when the plaintiff has filed the written statement along with of the. No, kindly give it.
The defendant number 3.
You are appearing for whom?
Defendant number 1, my lord.
Defendant number 2 file the rejoinder and the written statement.
Yes. Defendant number 3.
How is this prayer, my lord, maintainable as a co-defendant?
You are defendant number 1.
Yes.
He is for plaintiff.
Yes.
You file the written statement along
Against
with
the
the
defendant
counterclaim.
number 3, my lord, because the defendant number 3 had averred such statements, my lord, which are contradictory to my stand, my lord. That's why I am seeking for filing the written statement against the defendant number 3's.
It is not, my lord.
How the defendant can give the objection to the written statement to the
because they have a counterclaim there against the plaintiff also. And there are some statements which are against me, my lord. And because there was a consortium.
And when this written statement along with the counterclaim along with the written statement was filed.
My lord, that was filed, my lord, on. The date is not in my application, but my written statement is filed within 30 days. It is affirmed within 30 days, my lord.
So you are for the plaintiff.
I am for the plaintiff. My lord, this application
Which
is
for
not
the defendant number 3.
maintainable according to me.
He is not present today.
My lord, this application according to me is not maintainable. My lord, the provisions of the code also do not permit such a prayer. My lord, as a co-defendant, you don't have a right to file a rejoinder to the written statement by
Mr.
another
Kushal
side.
Chatterjee, my lord.
Who?
Mr. Kushal Chatterjee. And if the
then I'll use an affidavit and come back. My lord,
the defendant will file the written statement to the other defendant's counterclaim.
Well, my lord,
at best in trial, my lord, he can put some questions being a co-defendant to dislodge, my lord, that particular defendant's case. Otherwise, my lord, he has no other right.
You will file
Then I'll file an affidavit.
First. And what about the 8? GA8?
GA8, it's not filed by us, my lord.
Who has filed GA8?
GA8 has been taken out.
It was not been served also
by the defendant number, my lord, 3.
Praying for leave to
accept the written statement. Not yet accepted.
in view of this,
if it is within, my lord, 120 days, my lord, the out.
It is 120 days or not.
My lord, there is, I will use an affidavit here also because they had a copy of the plaint. Okay. My lord, there is one.
The defendant number 3 has and 7. 1 has filed an application being defendant number 1 has filed an application being GA Com 7 of 2025, praying for leave to file a written statement through the counterclaim filed by the defendant number 3. Defendant number 3 has filed an application being GA8 of 8 of 2025, praying for acceptance of the written statement. Counsel for the plaintiff prays for time to file written statement, filed affidavit in opposition in connection with both applications.
And I, my lord, raise an issue of maintainability so far as GA7 is concerned.
That affidavit, police. Counsel for the plaintiff has also raised objection with regard to the maintainability of the application filed by the defendant number 1, being GA-COM 7 of 2025. In view of the above, the plaintiff is given liberty to file written affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. Full stop. The maintainability of GA-COM 7 of 2025 is kept open. List the matter on 7th November. 7 November.
Grateful, man.
Grateful.
You are appearing for?
Defendant number 3. The order. Affidavit.
Not today.
My application. Mine. আমার অ্যাপ্লিকেশন বোধহয় আপনার নয় কি আছে লিস্টে DA3 is my application 41
or well, the original application is mine. I'm the petitioner.
which is item 17.
The interim order is expiring today, so I will be seeking
I
correction
am
of interim
objecting
order.
to that.
They have just filed an application for
GA3 is pending.
GA3 is my application under Order 1 Rule 10 for striking me out from the array of parties. But Your Lordship, there is an ad interim injunction against me, which I have duly filed the affidavit in opposition in due time as directed by Your Lordships. I have just received the reply. Your Lordship kindly keeps it any day for hearing. Kindly hears me out because a substantial amount has been injuncted, although I am not responsible. I will show it to Your Lordships. There's nothing which can bind me.
You are for the defendant number 2.
Yes, Your Lordship.
defendant number 2. Now, my lord, they have also taken out an application for
Under Order 1 Rule 10.
Deletion of their name
deletion of
and
their
rejection of plaint.
Yes, but
Against
that application has, I have not had a chance to deal with it. Kindly give me time to deal with it, the shortest possible time. My lord, kindly fix it.
Your Lordship, Your Lordship, it's an Order 1 Rule 10 application. Everything has to come out from the plaint. What will an affidavit in opposition? Affidavit
Order 1 Rule 10 application, I will have no right to file an affidavit to it.
With the deepest of respect, Your Lordship,
This
my
is not
learned senior
contested
friend
in the
cannot
report.
improve the case in an opposition.
Kindly gives me a
The
time to file an
defendant
affidavit.
number 2 has filed an application being GA-COM 3 of 2025, praying for rejection of plaint against the defendant number 2 and for deletion of the name of the defendant number 2 from the instant suit. Counsel for the plaintiff prays for time to file affidavit in opposition. Counsel for the plaintiff also prayed for extension of the interim order.
Yes, and my lord, the filing the reply in the main matter. Injunction application
The
reply.
plaintiff has filed affidavit in reply in connection with GA1.
GA1.
GA1 of 2024. Let the reply be kept with the record. Considering the submission made by the counsel for the parties, plaintiff is given liberty to file affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. Interim order is extended till 4th November 2025 or until further order, whichever is earlier. Let the matter appear on 4th November.
Your Lordship, I am only praying any time before the vacation.
Possible. They
Your
have
Lordship
taken
was
so much
substantial.
time.
I have not
They did
taken.
not even appear for 3
Your
months.
Lordship, there was issue in getting the visa, which I have applied, Your Lordships. Once we got
Yeah,
it,
visa and
without any delay, we had filed. Within the time, directed by your lordships, the affidavit in opposition.
No, no,
It's
the
a
new
very short
application-
matter, your
new
lordship.
application
Not
has
the
to be
new
dealt-
application. I'm not talking about the new application.
2 weeks, 1 week, 3 weeks.
I am not on that, your lordship. Your lordship keeps that after vacation. Your lordship, in the same suit, GA1 is by by the plaintiff, your lordship, where I'm suffering an order of injunction. There the
If you're telling that you are not the necessary
Exactly, my
party,
lord. And courts,
unless
Supreme
it
Courts
will
have
be
held that
decided how
human
you-
application has
how-
to be heard out first.
how you can argue in the injunction application once you are telling that you are not the necessary party, you will be deleted from the print.
So that would not be
Correct.
a hurdle. That injunction order that I'm suffering won't be a hurdle.
Yes, as per your submission.
No, I
As
am
per
not
your
saying.
submission, you are telling that you are a necessary party.
I am
and
not
that
a necessary
If any injunction order is there, it is not binding you. As per your submission.
Your lordship, once I have been made a party and there is an injunction order against me, that binds me as long as I'm there in the suit.
Both the application will be taken on 4th November. No problem. Let
He
the
has
matter
taken
appear
his
on
sweet
4th
time.
November
Let him
for
take
hearing
some
of
more
both
time and come back after vacation.
Both applications. Yes, next.
42, your lordship. And one more thing before going on to 42, item number 78 is the GA1. Let it appear together on the 4th November. And your lordship, item 42, 2 applications of mine. Again, GA4 is the order 1 rule 10, same nature. And GA3 is for filing the written statement, which is ready and affirmed.
No. 41 I pass an order.
Yes, your lordship.
What about the 42?
42 is a similar proceeding, a separate suit, your lordship. There also, I have filed 2 applications. I have filed the affidavit in opposition to the GA1. GA3 is my application seeking leave to file the written statement, which is ready and affirmed, your lordship. It within 120 days. And GA4 is again an order, an application under Order 1 Rule 10. So I am seeking leave to file the written statement.
When you receive the writ of summons.
Your lordship, I have received on 4th June,
Where is
your
your
lordship.
application?
GA3,
number?
your lordship.
Huh?
GA3.
Yes. When you received?
4th June, your lordship.
Where you mention?
Paragraph number 2, last line.
4 June during the summer vacation. 4 June 2025.
Yes, your lordship.
Correct.
And thereafter, your lordship, I have written statement. Your lordship kindly takes it from me. It is before 70 days. On 8th August, it was affirmed, your lordship. And we have filed this application. This master summons was taken out on 12th of August 2020.
No, where you file within 120 days.
Your lordship, 120s are not yet expired till date.
That's I'm telling when.
I am ready to file.
When the 120 is going to expire?
4th October, your lordship.
4th October.
So I am covered, your lordship.
Okay. Where is your written statement? Affirmed?
Yes, your lordship. Ready to be filed.
But I'm not object.
Item number?
Before the vacations.
Your lordship, I am carrying the written statement.
The plaintiff has the defendant number 2.
Yes, your lordship.
Defendant number 2 has filed the present application.
Filing a written statement and then saying I should be deleted from array of parties.
Your lordship, these are commercial suit. Your lordship knows that I will lose the chance.
Defendant number 2. 2. You are 2 or 3?
2, your lordship.
Defendant number 2 has filed the present application being GA-Com 3 of 2025, praying for extension of time to file written statement. So, counsel for the defendant number 2 submit that the defendant has received the writ of summons on 4th of June 2025, that is during the summer vacation of the school. Receipt of the writ of summons, the defendant number 2 has contacted the advocate on record. The advocate on record has instructed the defendant number 2 to provide all documents and instructions so as to enable the defendant number, so as to enable the advocate on record to prepare the draft written statement. Due to some the defendant number 2 has supplied the document, but in the meantime, the 30 days
Time for 30 days, time of 30 days for filing return statement expires. But the defendant has prepared the return statement and affirmed the same on 7th of August 2025, that is within the outer period of 120 days. And as such, he prays for acceptance of the return statement. Counsel for the defendant, counsel for the plaintiff has not raised any objection and submit that the return statement may be accepted. In view of the submission made by the counsel for the parties, this court find that though the defendant number 2 has received the writ of summons on 4th of June 2025, but the same could not, but the written statement could not be filed within the period of 30 days, but has affirmed on 7th of August 2025, that is within the outer period of 120 days. Considering the above, this court find that one opportunity should be given to the defendant to file defendant number 2 to file return statement. According return statement subject to payment of cost.
The Lordship kindly
Rupees 2,000.
Because it was affirmed within less than 70
legal
days.
service authority within a week from date. Understood? The department is expected to accept the return statement subject to scrutiny by the department. GA number disposed of.
But as far as GA number 1 is concerned, kindly allows me to file the reply
The counsel for the
and extend the interior model till 4th.
prays for extension of time to file affidavit in reply and also prays for extension of the interim order. In view of the above, time to file the affidavit in reply is extended for a period of 2 weeks. Interim order is extended till 4th of November 2025 or until further order whichever is earlier. Let the matter appear on 4th November. Okay?
3 or 4.
And GA4
is my order
is
not
the
told.
application, so well, directions for
The
affidavits.
defendant number 2 also filed an application being GA4, 2025, praying for deletion of the name of the defendant number 2 from the suit. Counsel for the plaintiff prays for time to file affidavit in opposition. That affidavit in opposition filed within 2 weeks. Reply is filed within a week thereafter. This is the matter of 4th. ठीक है उसमें हम लोग बोला ना रिटर्न स्टेटमेंट हैव यू सर्व द कॉपी टू द रिटर्न
That
स्टेटमेंट
is what I'm saying. He's showing rules and regulations. I cannot- Finding I did
counsel
not
for the
object,
defendant number 2 is directed to serve the
but
copy
should
of the
not be
return
put to
statement to
others.
the counsel for the plaintiff within a week from date.
Very, very Lordship. 8 statement of the below.
Yeah. Next.
Wait. Great.
Item 37. Mr. Singh, Mr. Singh has taken instruction, Your Lordship. We have spoken, Your Lordship, to Mr. Seal. Now, Mr. Seal is saying, Your Lordship, he can prove the entirety, but subject to cross-examination. So, if I say something today, Your Lordship, that I would be restricted, Your Lordship. This is a claim of more than 19 crores.
So that is better. Instead of all the thing conclusion, you call the Bandapad, that's examine and close it. That is the report says. Why you are going for the Kallol seal?
Kallol seal, Your Lordship, we
because
found, Your
the
Lordship,
report says that whatever the correspondence to be made by the Bandapad, you examine the Bandapad.
The issue with regard to best evidence depends on the person who is bringing
In the report, if there is a 5 person or 6 persons, 1 person is enough. But as per this report, the evidence required for the spot visit correspondence may be made with this one so. So it is clearly stated that tomorrow, if the Kalol will say that no, I cannot say it is a Bandapad, they prepared the report, then what we will say? Where is the report?
We have spoken to, yes, Your Lordship. He is one of, Your Lordship, the member, and Your Lordship, actually we have spoken to Mr. Bandopadhyay, and he has said, Your Lordship, he is the person, Your Lordship, who was actively, Your Lordship, participated in the entirety, and he knows the fact very well. So that's the only reason we wanted to call Mr. Seal.
He may call whoever. I am not coming in the way. But the
And
only
he's still-
issue is this: the evidence has to come to an end.
And he still remembers it.
This is the commercial suit. It has to be disposed of. Then it will take further 2 months for examining. Then again 2 months he will come. Yes,
Lordship is giving only 2 days time or 1 day
I
time.
will give. I am telling you, suppose the example. Then after 2 months he will come. Yes, the seal has stated that he is not the total aware of the fact. Then Bandopadhyay.
Let me call both of them if it is possible, Your Lordship, because
I don't know.
Lordship, let me call both of them then, Your Lordship. This subpoena is only for one person. If your lordship thinks that orders can be passed, otherwise your lordship kindly pass for Mr. Seal, and I'll take the subpoena for Bandopadhyay also.
And both are both in presence of the commissioner.
Yes, yes,
Yes. Mr. My only issue is, my lord, thereafter we'll put a time frame.
The
Whatever witnesses.
You are for the plaintiff.
I'm for the defendant.
The defendant has filed the present application being GA-Com 8 of 2025, praying for issuance of subpoena upon Mr. Kallol Seal, Scientist B, Central Forensic Science Laboratory, Kolkata, for examination on commission. For his examination on commission. Police. Learned counsel for the plaintiff raised objection and submits that they have no objection for issuance of subpoena upon the Kallol Seal for examination by the defendant, but the plaintiff has relied upon the letter dated 20th August 2016 issued by the Director, Central Forensic Science Laboratory, Kolkata, wherein in fifth paragraph of the said letter, it is recorded that if evidence is required for a spot visit report, correspondence may be made with Sri A. Bandyopadhyay, Senior Scientific Officer and Scientist within hyphen B within bracket explosive of CFSL Kolkata, who is the authorized team leader, quoting CFSL forensic report number and the date invariably. Inverted comma close. Police counsel for the plaintiff submit that if the defendant submit that they will not examine Mr. Bandyopadhyay, then the Kallol can be examined because Kallol Seal can be examined because this is a commercial suit and the suit is to be disposed of as early as possible. Considering the submission made by the counsel for the plaintiff, the defendant, counsel for the defendant submit that he will examine both the witnesses on commission and prays for issuance of subpoena upon both the witnesses, that is Mr. Kallol Seal as well as Mr. A. Bandyopadhyay. In view of the submission made by the counsel for the defendant, the department is directed to issue subpoena upon Sri Kallol Seal and Mr. A. Bandyopadhyay. Both are scientists B of the Central Forensic Science Central Forensic Science Laboratory, Kolkata, for their examination in the present case before the commission. The defendant is directed to take appropriate steps to file requisites in the department within a week from date for issuance of subpoena upon the said two witnesses. Police stop. The earlier who was the commissioner?
Mr. Prabhakar Chaudhary has been.
He will continue. Yes. Mr. Prabhakar Chaudhary, an advocate of this bar has already been appointed as commissioner for examination of the witnesses of the case. Accordingly, Mr. Chaudhary is directed to continue to be as commissioner for examination of these two witnesses on commission and to complete the evidence of these two witnesses within a period of 4 weeks.
4 weeks.
But Puja vacation.
I will kindly keep it 2 weeks or 3 weeks after this.
Within a period of 4 weeks after the Puja vacation. And is directed to file a report by 2nd of December 2025.
Great.
ये संसेशन डिस्पोज ऑफ है वो कॉपी उनको देने की इनको वापस ये रखो.
May I take back the report, Your Lordship?
And my lord, may this be peremptory, no further extension, because my lord, on several occasions they've come up with new witnesses.
The commissioner is directed not to give any unnecessary arrangement to any of the parties without unnecessary arrangement. क्या बोला? The commissioner is directed any unnecessary adjournment to any of the parties.
My lord, I am
Your-
opposing this application.
Yes, Your Lordship, I appear on behalf of the plaintiff. Your Lordship, this suit is currently at the stage of evidence and the cross-examination of the defendant's witness is ongoing. My learned senior, Mr. Bose, was in the midst of cross-examination. On the last date, Your Lordship had passed an order. Your Lordship, it's at page 11 of the application. In that order, you had noted that we had issued a notice to produce certain documents to the defendants. Those documents have not yet been produced. It's been over a month. The next date of hearing is the 17th of September. They had admitted that they would produce the documents. It would require some time, but it's now been over a month. And the next date of hearing is the 17th of September, where the cross-examination is to continue. So we would require those documents to be produced.
My lord, may I request your lordship to take up this matter, my lord, next Thursday? Let me seek instructions, my lord, about the documents. I don't have instructions as of now. And in the event, my lord, the documents are available and bank is in a position to disclose them, I'll come and indicate. Because the cross-examination is fixed on 17th, I think it depends upon the
7th
September.
of September.
September.
Yes.
So what you want now?
I want, my lord, 3 days time to take instructions. I'll, my lord, on the basis of this application and the order which lordship had passed on the last occasion in course of, my lord, the cross-examination. Which
When they receive the letter, then they will require some time to trace out the document. And after tracing out the document, the same will be produced before this.
Yes, so my lord, I'll take instructions from the bank's officer, concerned officer, keeps it, my lord, Thursday or Friday, whichever day is convenient, my lord.
We are for the defendant.
No, Your Lordship, the plaintiff.
Counsel
I am for the defendant bank.
counsel for the plaintiff has filed the present and the plaintiff has filed the present application, being GA-Com 9 of 2025. Praying for the direction upon the plaintiff for production of the document for inspection as mentioned in paragraph 7 of the present application. Counsel for the plaintiff, counsel for the defendant, prays for 2 days time to take instruction whether the document, whether the plaintiff is able, whether the bank is able to produce the document or not. In view of the submission made by the counsel for the defendant, let the matter, it will fix on 17, na?
Yes.
Let the matter appear on 11th, आज कितना 8 तारीख है? 11th of September 2025 has to be mentioned on the court, has to be mentioned. Next. Not today.
My lord. Appear for the applicant, my lord, and defendant applicant, my lord. The application is at my instance. Praying for, we have all the written statement of the defendants, my lord, has been filed within a period of 120 days. We are praying for.
You are for the defendant.
Defendants.
Sole defendant.
All three.
All defendants.
2 defendants.
When you receive the writ of summons.
Writ of summons.
Was served on 27. Writ of summons date,
kindly comes
9th April.
9th of April. The time for 5 was within 6th of August, my lord. We have came up before your lordship and taken a leave, and thereafter 5.
When you filed the written statement, when you submitted the written statement in the department with the leave of
2nd of August, my lord.
2nd of August.
We have not received the written statement yet, Lordship.
If my lord so desires, I can hand it over.
Yes.
Lordship, as formal objection may be recorded, Lordship, as 30 days have been passed. So,
have you
Lordship,
copy of that? Have you copy of the written statement?
Yes.
kindly pass the necessary
Have you
order
taken the
with
copy of
cost.
the filing in the department?
Yes. We have mentioned before your lordship, and
Correct,
leave
correct,
was
correct.
taken. Thereafter, we have filed in the department.
On 2nd of August.
2nd of August.
The defendants have filed the present application being GA-Com 2 of 2025. Praying for acceptance of written statement. Praying for extension of time to file written statement. Defendant बोला ना? Counsel for the defendant submit that the writ of summons were served upon the defendants on 9th of April 2025. After service of writ of summons, the employee of the defendant has took some time to trace out the relevant documents relevant document from the divisional office, and as such the defendant could not file the return statement within the period of 30 days. He submits 30 days, but the return statement was affirmed on 2nd of August 2025, that is within the outer period of 20 days, 120 days, within the outer period of 120 days. And with the leave of this court, the written statement was submitted in the department on the same day. Counsel for the defendant submitted. There is no willful intentional delay on the part of the defendants, but the defendants have filed the written statement within the outer period of 120 days and prayed for acceptance of the written statement. Full stop. Counsel for the plaintiff raised objection and submitted that the writ of summons was served upon the defendants on 9th of April 2025. And as such, the defendants ought to have filed the written statement by 8th of May 2025. But the defendants have not shown any cause as to why the defendants have not filed the written statement within the period of 30 days. She further submit that as the defendants have not shown any cause for filing the written within the statutory period of 30 days, and as such she prays for dismissal of the present application. Had the learned counsel for the respective parties peruse the application. Admittedly, the writ of summons was served on 9th of April 2025, but the defendants could not file the written statement within the period of 30 days. This court finds that the defendant has taken shown a specific cause that after service of writ of summons, the defendants has took some time to trace out the documents from the divisional office, for which the defendants could not file the written statement. Admittedly, the defendant has affirmed the affidavit on 2nd August 2025 and filed the same in the department with the leave of this court on 2nd of August 2025 within the outer period of 120 days. Considering this said fact, this court finds that one opportunity should be given to the defendant to file written statement subject to payment of cost of rupees 2,000 to the High Court Legal Service Authority within a week from date. Full stop. The department is directed to accept the written statement filed by the defendant, submitted by the defendant on 2nd of August 2025, subject to scrutiny by the department. The plaintiff is and the defendants are the counsel for the defendant is directed to serve the copy of the written statement to the learned counsel for the plaintiff by tomorrow. Full stop.
By Wednesday, if my lord.
By 11th of September 2025. GA Com 2 of 2025 is disposed. Yes.
The cost to be deposited within
1 week.
May I read the order be served today? Since the nationalized company, again they will be taking time. Or if my lord kindly extend to 2 weeks, my lord, to deposit the cost.
Okay, 2 weeks. Depositing cost within 2 weeks.
Great.
I'm for the plaintiff.
Sir, I am opposing this
Application for amendment of the plaint.
Amendment of the plaint.
Yes. Lordship will not go by the indicated amendments in the plaint because these are all without corrections and modifications of the same pleadings. In this, it was filed in city civil court, so they had the learned advocates of that court had handled the plaint at that point of time. When we have come here, it's a transferred suit. Lordship would remember it come from under Order 7, Rule 10. It had gone to appeal court, and appeal court transferred the suit to High Court. That one. So
plaint and incro was then.
So we have to bring it in the original site form. And only material change is page 40.
That law still has not been settled. What would be after it?
But it's same problem. There are 38 matters now before the other court. Everybody is stuck with the same point. How to deal with that transfer? Non-commercial dispute, file the non-commercial division or otherwise. How to transfer? Under section 15, pending suits can be transferred, but new suit
can't be.
It has to be dismissed.
Order 7, Rule 10.
Now, if it's in the commercial division, in non-commercial division, that act is not applicable. So that is the dispute now. Mr. Ghosh is arguing, Mr. Molla Ghosh is arguing in one side, Mr. Dutt is arguing on the other side. The point is being deliberated. There are two division bench. One is this matter, which applied Order 7 Rule 10B, but that provision is not applicable in the original side. The other is Justice Sen's division bench.
That's in my order.
Yes, from Lordship's order. There was also a dispute regarding the, because
that is also
somebody
not
given
clear.
consent, then consent withdrawn, that issue was there. Under 151, the division bench transferred that proceeding. These are two available orders of appeal court. Rest are, we have a lot of suits pending. Now, Milord.
What objection?
Milord, twofold objection, Milord. Milord, my learned senior friend has pointed out, Milord, that he requires this plaint to be amended to be able to, Milord, make this plaint compliant of the Commercial Codes Act. Milord, that liberty perhaps was granted, Milord, on the 19th of December 2024, Milord, kindly takes page 16 of their application, Milord. Page 16, Milord, the order of the division bench, Milord, at page 17, paragraph 4. Keeping in view of these submissions, we grant the liberty to the appellant, Milord, the plaintiff, to incorporate the necessary consequential additional paragraphs in the plaint and to alter the court fees accordingly in the plaint, which is now to be filed before the appropriate court. Subsequently, Milord, the plaint was presented before your lordship. Milord, the plaint was made compliant of these of the liberty granted to them in paragraph 4, Milord. Now, Milord, what they have done is, Milord, Lord, if your lordship kindly takes the proposed amendments, Lord, it starts at page 25 of their application. Lord, Lord, these are all handwritten proposed amendments. It's very difficult to decipher. Lord, what I've been able to understand from the prayers that they are asking for is, my lord, to introduce further documents by way of amending the plaint. My lord, that cannot be done in my respectful submissions, my lord, without filing a proper application. My lord, what they try to do now is incorporate these further documents without giving us those particulars of the documents. These, my lord, the amendments that they are asking for is also to introduce fresh documents. Now, my lord, where are those fresh documents?
Problem is that you kindly come to the page.
Page document কোথায় পেলো? তো ফেজ ডকুমেন্ট কি দিচ্ছি না, কোথায় ফেজ ডকুমেন্ট?
বুঝতে পারছি না কি এফআইআর
Those are all pleaded in that plain.
It's not there.
Document, I am not annexing any document. মানে এখানে কোনো document annexion নেই।
তুমি paragraph
যেমন annexed তখন আমি সেভাবে করে দেবো। Only thing is that documents relied on, which has been annexed now. That is the only difference with the code below and this.
Incorporate new documents.
আরে those আচ্ছা বলে দিচ্ছি দাঁড়া। Those were needed. হয়তো লাগতো না, এখানে তো লাগবে দিতে না।
Documents which are relied on as an annex to this plate subsequent.
Same document which were there, but anyway, I'm going to check.
Relied on, relied upon the justify the claim, therefore requested to disclosed. Relied on যেটা ছিল
কোনোদিন এখানে ঝগড়া করে তো কোনো লাভ নেই, তো একটা পয়েন্ট বলেছি, এটা আনসার করতে হবে।
ঠিক আছে,
কিন্তু তো একটা পয়েন্ট বলেছি।
Into the old plate, it's documents which are annexed to the plate and documents which are relied by the plaintiff. Now this relied on the plaintiff unit, those documents has to be disclosed in the commercials and which will be done. And that is the only liberty sought for. There's no change in document.
Yes, kindly come to the page 14, paragraph 11.
Yes, Punam.
That was the difficulty facing by the plaintiff. This timeline, so they will not be able to file the plaint.
I could not.
Yes, my lord. Yes, my lord. Subsequent to this order, my lord,
This
the
order, no,
the
this
nine-
order was passed. This order was passed on 16 December.
Yes, my lord.
And the court has
3 days
granted by 24.
Yes.
Correct. by 24, and the print shall be appear before the said court presented on 6th of January 2025.
Yes.
So what they have done they have filed the give the file नहीं है छूट है यहाँ में. So they have filed the new plaint.
Yes.
They have filed the new plaint along with annexing the plaint of the other suit.
That is annexed.
Suit filed before the city civil court.
Yes.
And that has been admitted here. Now they wanted to incorporate the averment made in the city civil court.
Yes. Lordship, since Lordship is page, kindly comes to page 16, Millard. 19th December order. My learned junior friend was showing page 17. I'm bringing Lordship's attention to page 16, Millard, second paragraph. My submission is recorded here. On the basis of this submission, that order was passed.
Correct.
I said that in the commercial division, if I want to file a suit of city civil court before this court in the court, the division will not accept it. So that I sought for that liberty to that I will make into the form of original side, and that part was allowed, nothing more than that. So I had to annex the plaint of the city civil court with that plaint. Lordship has observed that. Now, Millard, here what I am doing, there are in the city civil court or in the regular suits or chip knows, the documents need not to be disclosed at the time of filing of the suit. I have pleaded all those documents in my plaint, but those are not annexed or disclosed. So those documents which I had relied upon at the time of filing that suit before the city civil court, I am disclosing here. I have to. I am also seeking a leave to file a fresh affidavit under order 9 that I have to file under the commercial division. And there is only one material change at page 41. Lordship would find page 41 and 42. The figures are changing.
Yes.
That is the only material change.
Introducing a new bill.
No, I am not introducing a bill. I am giving him extra benefit. When you heard extra benefit, kindly come to page 42. This is page 41 is the paragraph 20. This is the money that I have received from the defendant. Paragraph 20. These are the figures. At the end of that page, a date is added and a figure is added. I missed out this figure which I received from them, and I have given him adjustment of that. That is the change. Figure is increasing because of interest and the calculation. I am not increasing any bill. I am increasing an adjustment that is to be given to the defendant. And that is why, Lordship, page 42, at the end of the chart, the original adjustment I was giving 2,05,000. Now I am giving 2,20,000. 15,000 I am adding.
Come to the 41.
Yes,
Paragraph
41.
20.
Yes.
What you
It was originally written as the defendant in order
to discharge the liability. Yes. Now you wanted to defend in order to discharge the liability, and further made you wanted to delete.
Yes.
Then what?
These are the dates on which defendant made these payments.
What is your amendment?
The amendment is that the Lordship would realize the changing that is original. I am reading the original, Millard. The defendant, in order to discharge its liability, made further payment on different dates during the month of May 2016 to June 2018, and the particulars thereof are as follows. This is original. I am making it into the payments on different dates the plaintiff received from the defendant between 2016 this date and the particulars thereof are as follows. Just the meaning is same.
No. Then the above aforesaid payments, however, that is
part of paragraph 19.
That is paragraph.
That is coming after this chart of paragraph.
The plaintiff received from the defendant.
Yes, same.
Then
it's from the defendants. The following payments on different dates.
The following payments.
The following the chart is given thereafter.
The read it. The plaintiff received from the defendants,
payments on different dates,
payments from different dates
in 2014 and thereafter 2016 to March 2018, and the particulars thereof are as follows.
2014 and thereafter
between 2016 to March 2018, and the particulars thereof are as follows. These dates and the meaning is same. Once I say I received from him, other I say he paid me. That's the thing.
That's the difficult. It's very difficult to decipher from the handwriting.
Because it's handwritten.
You come with a type copy.
Because it's handwritten, and
otherwise you will be in difficulty in the department.
No. In the department, what happened in the original side rule, Lordship remembers when the rules were framed, there was no type copy. Originally, people had to be making in the handwrite. Now the type copies are there and we have to incur. So when he talked to the department did not stop it. They said that yeah, this is the right form, please do it. We did. Obviously, when we ultimately incorporate, we have to incorporate in the type
No,
form.
that's correct, but it will be
The
okay.
only change is that is the last page, paragraph 41, last entry. This is the only change.
Okay.
And the figures are changing because of the calculation.
Lord, I will file an affidavit.
And the short direction of affidavit, otherwise.
Plaintiff has filed an application being GA-1 of 2025, praying for amendment in the written statement, amendment in the plaint. Counsel for the defendant prays for time to file affidavit in opposition. Let affidavit in opposition be filed within 2 weeks.
2 weeks.
Reply if any there to be 1 week thereafter. Release the matter on 7th November. Yes.
7 November. Grateful.
So this I am for the petitioner. This is an application under Order 13A, Your Lordship, of the Code of Civil Procedure, in respect of a commercial suit or summary judgment. Unless and until Your Lordship, the affidavits are filed, and that is also after 30 days, Your Lordship, as per the statute, it cannot be decided. Lordship, only direct Your Lordship, I know, but
which for the defendant?
We have served Your Lordship the copy, but they are not appearing today. But Your Lordship will again, Your Lordship, serve the copy. Your
Affidavit
Lordship,
of service filed by the plaintiff be kept with the record. Now, upper karo. The plaintiff has filed the present application being GA-1 of 2025 under Order 37.
Under Order 13A of the Code of
13A.
Civil Procedure.
13A of the Code of Civil Procedure. Praying for summary judgment. Affidavit service filed by the plaintiff be kept with the record. Okay? Full stop. As none appears on behalf of the defendants, comma, the plaintiff is none appears on behalf of the defendant, comma, the defendants are liberty to file affidavit in opposition within 2 weeks. Reply, if any, there to be filed within a week thereafter. Release the matter on 7th of November 2025. The plaintiff is directed to communicate this order to the defendant for the knowledge of the defendant. Next. Yes.
I have not served on the other side. The writ of summons has not been served.
Which one?
The next, 48, yes. I took leave from your lordship on 13th of August to file this application because this is an application for when the plaint was presented on 18th of June. Thereafter, some documents were discovered by me. So I have taken out an application. One is for the discovery of those documents, and like the last matter, I have not taken that chance to by amendment incorporating that. I have filed a separate application for amendment. So if allows this, I can send the entirety by issuing the writ of summons. Because till that I have not served the writ of summons. So I can send the amended plaint and the.
So GA1.
GA1 and GA2, two applications.
GA1 is amendment.
I don't know that time we are GA1. If kindly takes the prayer once. One is amendment, one is discovered.
One is amendment.
Amendment, very well.
And GA2?
GA2 is discovery of documents. Then I'll serve with the
disclose. Yes. Record and on. The plaintiff has filed 2 applications being GA-1 of 2025 and GA-2 of 2025, praying for amendment in the plaint as well as disclosure of additional document. It is found that the writ of summons has not yet been served upon the defendant. Accordingly, the plaintiff is directed to take appropriate steps for lodging writ of summons
after amending.
No, not been served, na? क्या बोला? Upon the defendant, full stop. Okay, then the plaintiff is directed to serve the copy of this application to the defendants within a period of 1 week.
No, what I was saying, if allows this, I can serve the amended copy.
How it can be?
Writ of summons,
let the copy be served.
That
because the additional document. Tomorrow it will be difficulty. You saw this copy?
Very well.
If
Can
they
it
will,
be
they will
7 days?
proceed within
Both the
a period
matter.
of 1 week from date. Let the matter appear on 18th September 2025. The plaintiff is directed to file the affidavit of service on the next date fix, on the returnable date.
Both the applications.
Your Lordship recalls, my lord, this was an application taken out in respect of all the defendants, in respect of goods, my lord, which were exported to India from Australia. My lord,
What is the application for?
it's a composite application, my lord, for judgment upon admission as well as for injunction and attachment.
Nobody's appearing.
Nobody's
Notice out.
My lord, in fact, today it was fixed because the defendant numbers 2 to 7 had not been appearing.
After service.
After service. But there's only one thing which is pricking me, my lord. In the event the matter is taken up and any order passed today, the difficulty might be they might take this plea later. But nonetheless, my lord, the issue is your lordship recalls Mr. Jishnu Shah was appearing for the defendant number 1. The defendant number 1 has suffered CIRP. In fact, this matter was argued threadbare, my lord. I was being led by Mr. Abhijit Mitra at that given point of time. The issue is, my lord, there were...
If the defendant was in the CIRP, then how the suit can proceed against him?
I'm not proceeding against the defendant number 1
So?
at this moment, my lord, because the moratorium is in place in respect of the defendant number 1.
Correct.
But in respect of the other defendants, my lord, I can proceed.
Okay. So how the judgment upon admission can be passed?
Judgment upon admission, perhaps at this juncture, my lord, I won't be able to press for because the admission, according to me, my lord, would be rather, it can be applicable in case of defendant numbers 2, 3, and 4. But insofar as the prayer for injunction and attachment, my lord, is concerned, that perhaps can be entertained by your lordship in respect of all the defendants, 7 except the defendant number 1, my lord, who has suffered CIRP. They have also not, the rest of the defendants, my lord, they have also not filed any affidavit in opposition to this particular application.
But the injunction also you're praying for the defendant, not particularly.
No.
Then.
So that's the reason why, my lord, perhaps I would be entitled to proceed. If not, my lord, the judgment upon admission, I can always proceed, my lord, in respect of...
Interim also you have not stated that only against defendant number 3 or 2 or 1 because defendant.
Yes, because, my lord, it's essentially, my lord, this is a claim, my lord, where it's a prayer for goods sold and delivered, money not paid. And I've been able to demonstrate, my lord, in my plaint, as well as my application, that all the defendants have been acting in tandem with one another. For that, my lord, I would
want to. What you will do now?
Today, it's a difficult, I'm on a sticky wicket. Otherwise, if your lordship just hears me out a part of it.
Though the matter is specially fixed today at 2 p.m. but due to the bar resolution, but none appears on behalf of though the matter is fixed today at 2 p.m. Learned counsel for the plaintiff is present, but none appears on behalf of the defendant. Due to the bar resolution, the case is adjourned. Let the matter appear. Give the date. 6. कहाँ से 16 सितंबर होगा? November 2020 at 3 p.m.
Yeah, is it your lordship's pleasure to fix a time, my lord?
3 p.m.
3 p.m. Very great. 25th November.
Yes, next.
May it please your lordship, my lord, I appeal for the petition.
Yes.
Yes, my lord, is appearing for the first time.
What is the application?
The application is for injunction in connection with the suit for recovery of money on account of refund of the price paid for allotment of shares. Now, the plaintiff, which is now in CIRP, has filed the suit through the resolution professional. So it's really the resolution professional who is the plaintiff in this suit, filing it on behalf of the plaintiff who is undergoing CIRP. Now, this company, the plaintiff, had paid application money, paid share application money for allotment of shares. Often in the defendant.
Have you served the notice? Have you served notice?
We have served the postal envelope has come back with addressee there. But for the we have also served by an
email which is
Yes. So where is the notice service?
email service. Oh, lordship given email service document.
No, where is there is no service. Item dispatched.
After the postal receipts came back, may I just
Where is the email service?
may I kindly show my lord page 8, my lord.
Yes.
This one.
Yes, where is the service?
This is the letter with the two annexes at the bottom, my lord. This
Where is the
email.
service?
On the same day,
Where is show me the received?
No, this is an email I'm showing, my lord.
Email where is the postal? You send the postal.
I had sent the postal, my lord. After it came back, I sent another email on the 1st of September, which is, my lord, at page 8. But I'm also carrying the original of the document that was returned back. After it was returned back, I had served on email.
Yes.
Yes, my lord, may I?
But
My lord,
today,
the application.
Today, as per the bar resolution, can the matter be taken in the absence of the other party?
My lord, then kindly takes it up. I understand.
The plaintiff has filed the present application, praying for interim order. Police of the print. As per the service report, as per the affidavit of service, it is found that the postal service has returned with the endorsement.
Address left without instructions.
Without instruction, but the plaintiff has served the notice through mail on 1st of September 2025, but that was not returned to the plaintiff. Police stop. Police stop. Due to the bar resolution, it is not possible for this court to take the matter in the absence of the defendant. According cases adjourned. Let the matter appear.
Could we come back day after tomorrow morning instead of tomorrow?
Let the matter appear on 11th September. Next. Yes.
The small application for amendment of the cause title. No, it's not only for amendment of cause title. Perhaps, my lord, my learned friend won't have a right of audience in this application. May I just indicate the amendment only? My lord, this was a suit, my lord will recall, relating to a letter of comfort. Mr. Chaudhary was leading me in the matter. My lord had delivered a detailed judgment, whereby my lord had dismissed my prayer for judgment on admission, had dismissed my learned friend's application for return of plaint because of territorial jurisdiction. Both parties failed to succeed before my lord. We thereafter sought to proceed with trial. Now, during the pendency, after inquiry, we found out that the defendant number 2, who is not a necessary party in the suit, against whom I don't have a single relief, defendant number 2 has gone into CIRP. Now, today I am seeking to I am not seeking any other step in the suit. I am only seeking to put the IRP of or rather the resolution profession of the defendant number 2 also as party in the suit, in the capacity of the defendant number 2's management. That's all. Malad will kindly take page 34. That is the totality of the amendment I'm seeing. Page 34. Nothing more.
Yes.
No prayer, no nothing. Now, one also, just to counter, I apprehend that a submission will be made that the entire suit has to be said. Just to counter that, Malad will kindly take page 47, para 30 of the plaint. That's the original plaint. I have not amended this. Para 30, Malad will kindly consider. I have a specific Yes. pleading that I do not seek any relief against the defendant number 2.
Why are they not deleting?
He's
Yes.
a proper party. No, 1 second, my lord. He's a proper party in the suit. My lord, that was our stand. He's a proper party whose presence is required only for adjudication of the suit. I'm not seeking a single relief against him. He's not a necessary party in the suit. If my lord today orders the defendant number 2 to be expunged also, I don't have a real difficulty. We've impleaded so that a point is not taken by the defendant number 1 later on that a proper party to the suit is not impleaded. That's all. This is the totality of the amendment I'm seeking. Now, just to buttress my submission that merely because an order of moratorium is passed by the NCLT, just on that basis a suit will be stayed. Well, just one judgment. I don't want to take my lord's time too much. One judgment of the Honorable Delhi High Court.
arbitration proceed করতে পারে তো
না একবার প্রতিবাদ arbitration context but not exactly. My lord, we kindly take paragraphs 5 and 6. It's not, my lord, there has to be some discretion. My lord. Paragraph 5 and 6.
in power grids matter.
Yes, I wanted to rely upon it because of the name of the case. My lord, paragraph 5. A learned single judge of this court in Power Grid Corporation, whom my learned friend today represents, has held that the embargo under section 14(1)(a) would not apply in all circumstances. So it's not a mandatory bar to all suits. My lord, we kindly have a look at this. Hence, for the following reasons, I conclude that the proceedings would not be hit by the embargo under section 14(1)(a), which proceedings do not mean all proceedings. Moratorium under section 14(1)(a) of the code is intended to prohibit debt recovery actions against the assets of the corporate debtor. My learned friend is not the corporate debtor. Continuation of proceedings under section 34 of the Arbitration Act which do not result in endangering, diminishing, dissipating or adversely impacting the assets of the corporate debtor are not prohibited under section 14(1)(a) of the code. Term including thereafter, my lord, will skip over. It expands on this, and paragraph 6 is the learned judge's own finding in this judgment. A perusal of the judgment shows that until and unless the proceeding has the effect of endangering, diminishing, dissipating, or adversely impacting the assets of the corporate debtor, it would not be prohibited under section 14(1)(a). 14(1)(a) of the IBC also, my lord, will kindly have a look at. It's where the essence of the legislation is where I am seeking reliefs or trying to affect the assets of the corporate debtor. Then suits may not proceed. And this is even prior to that. I am not seeking to proceed in the suit. I am just bringing on record the IRP so that if the defendant number 2 wants to file an application for stay, let them do so. My learned friend today for the defendant number 1 has no right of audience at this stage. It is a plaintiff seeking a simpliciter amendment of the cause title. Simpliciter. And section 20 of the Insolvency and Bankruptcy Code, my lord, can only note, section 20 of the IBC specifically provides that the resolution professional will take over the management of the corporate debtor. Only for that reason to bring in the IRP, that's all.
Yes.
Yes, my lord. He has very eloquently, my lord, indicated, and but perhaps it is the issue is not that he is only, my lord, praying for an order that the cause title of the plaint be amended. In fact, my lord, he has prayed for an order to allow the amendment. So, my lord, lordship will see the proposed amendments. He wants the resolution professional to be implemented in place instead of the corporate debtor.
What in places?
My lord, kindly see para 34. Para 34 is
34 of application.
Yes, 34 of the application, which is internal page 2 of the proposed amended plaint.
Yes.
Represented by the resolution professional, my lord, defendant number 2. So, my lord, he wants the resolution professional to be brought forward to contest the present proceeding. Now, my lord, there are few documents that he has disclosed. Now, the reason is, if he has any claim or if he has any action against any corporate debtor which has gone into CIRP, my lord, he has an alternative remedy. The remedy is under the CIRP regulations. My lord, if he has any right, if he has any claim, he can go and lodge his proof of claim. My lord, he has not done that. That is the reason why he wants the IRP to remain. Kindly see, my lord, CIRP commenced on 4th of June 2024. The order is at page 9. Public announcement was made on 6th of June 2024. Lordship will kindly see that document, page 7 of the application. This is the public announcement, page 7.
Yes.
Kindly see, kindly comes to the next page, page 8. My lord, once a public announcement is made by the RP, my lord, it is notified to all concerned that the corporate debtor is in CIRP. and a time limit is prescribed for the creditors of the corporate debtor to come and lodge the claim. His time has gone. Kindly see, my lord, the second paragraph after the box. The creditors of Messrs. Nowlin Infrastructure Private Limited are hereby called upon to submit their claims with proof on or before 20th of June
Correct.
to the interim resolution professional at the address mentioned against entry number 10. But this has gone. He has not lost his proof of claim. Application is filed in 2025. Now, more importantly, whether at all, Malad, the resolution professional has been conferred with such duties to contest and defend such a proceeding against the where the corporate debtor is involved. My learned friend cites section 20. Lordship will see section 25. Section 25 of the Insolvency and Bankruptcy Code. It's completely, my lord, in a different arena when compared with section 35 of IBC. Kindly see section 25. Duties of resolution professional. The most relevant provision that he can take recourse to under 25 is 25(2)(b). Represent and act on behalf of the corporate debtor with third parties, exercise rights for the benefit of the corporate debtor in judicial, quasi-judicial or arbitration proceeding.
Yes.
So resolution professional can only be brought on record to, my lord, in respect of a proceeding which is for the benefit of the corporate debtor. So resolution professional will proceed with the action which was initiated by the corporate debtor.
Correct.
The law, that is 25(2)(b, does not say that he will defend. And the judgment that he has cited, 2019 SCC Online Delhi 9339, this was an action where the corporate debtor was the claimant. Kindly see para 2 of the judgment. The plaintiff company has since gone into insolvency and a resolution professional has been appointed. The question has arisen as to whether the adjudication of the counterclaim would be liable to be stayed in view of section 14. Similarly, now Mulad, this is the duty. It does not.
See, you are appearing for whom?
Mulad, the defend number 1.
1.
Yes.
You are not for the 2.
No, I am not for the
Correct. Now the 2, kindly come to the prayer portion of the
Yes.
plaint. Prayer of the plaint. Prayer of the plaint is only with regard to the defendant number 1. It's not asking for any benefit or any prayer, any relief against the defendant number 2.
Yes.
Correct. So his submission is that the defendant number 2 is only a proper party and not a necessary party.
Is that
So
he is saying?
He is not asking for any relief. And only for the sake of the information of this court, the defendant number 2 is under the CIRP. Moratorium is there. If the moratorium is the CIRP, so the defendant number 2 cannot be a party simpliciter in the suit against the defendant number 2. So that's why he should be only for the benefit, for the knowledge of the CIRP that yes, there is a suit pending. That's why he should be a.
No, then your lordship will kindly see the pleadings in the plaint. The nature of the transaction was goods were supplied by the defendant number 1, defendant number 2 to him.
Correct.
Sorry, he supplied goods to the defendant number 2.
2.
He has a claim.
Correct.
Now, my lord, the transaction is that I gave a comfort letter.
That's why you have given a comfort letter. If he will not pay, you
Yes.
you will
Now
pay,
the
and you need not
comfort
to.
letter
you need
issue
not
is
to-
already over.
It's not
Comfort letter issue on the basis of the comfort letter, which according to him was a document for guarantee. He filed an application for judgment upon admission that I have admitted my liability pursuant to the issuance of the comfort letter. Now that chapter is over. Lordship has rejected the application. No appeal. We have accepted the order. Now, Mulad, even if the suit proceeds, he cannot fall back on the self-same argument which your Lordship rejected at the judgment upon admission stage.
That is the main argument. That is.
But most importantly, Malad, the suit now proceeds against a corporate debtor which is in CIRP. The IBC, Malad, does not provide or give powers to the resolution professional to defend such a proceeding. If he agrees to delete the name of the defendant number 2, Malad, I will take a step back. But kindly see, Malad, section 20, because during CIRP, the resolution professional has not been given such a power. The power to defend proceeding is given post completion of CIRP, that is when it goes to liquidation. Kindly see section 35(1)(k).
35 1K, 35 is powers and duties of liquidator.
Correct.
Liquidation is post CRP if CRP is unsuccessful. Kindly see K. To institute or defend any suit, prosecution or other legal proceeding, civil or criminal, in the name on behalf of the corporate debtor.
Correct.
So the resolution professional has not been conferred with a power to defend such a proceeding, which the liquidator has been empowered under 35 1K. His prayer is defective so far as IBC is concerned. And suit your lordship is trying in term or adjudicating in terms of the Commercial Codes Act 2015.
No. Now, at present, the stage of the liquidator has not come.
No, because it's still in CIRP.
Still in CIRP. Correct. It's still in CIRP. CIRP, the resolution professional has been appointed.
Yes.
Correct. To take over the charge of the company in question.
Yes.
So now the resolution professional has to inquire and to submit the report, then the liquidation will come.
No, resolution professional, the first duty is to collate all claims
Correct.
from the
That's why I mean inquiry. So all collate whatever the assets are there.
Yes.
And he will submit the report,
Yes.
whatever, and whether it will be accepted or not accepted,
Yes.
that is the up to the tribunal. Now, here the defendant number 2 is the party.
Yes.
As per his case, that is not a proper party. It is a necessary party. It is a proper party, but it is not a necessary party. Leave aside that. But he has not prayed for any relief against the defendant number 2.
Yes,
If
he has not prayed for.
Prayed for any relief against the defendant number 2, and if it is not that, if he has been added, this court will allow that through the resolution professional appointed by the tribunal. So naturally, the press notice is to be given to the IRP.
Yes, summons has to be served.
Someone has to, if then he will had a knowledge with regard to this suit. So he can come and say that I am not aware, then I can be deleted. At this stage, how you can oppose that?
No, there is a reason, Malad. Kindly see what is the scenario. The CIRP has commenced in June 2024. The IBC provides that he has a time limit of 270 days.
That with regard to that, that's why he has no claim against the defendant number 2. Subsequently, we don't know. Subsequently, neither you nor this court know, because he has not raised any claim either in the suit
or against
that. He has not raised.
Yes, but I am on this, my lord. How can he implead the resolution professional?
Only for the knowledge.
No, but the IBC, my lord, even if the resolution professional is impleaded or he is made the defendant number 2, but he will come and say that I do not have powers. IBC has not mandated me to defend the suit. Because his power,
let the IBC come, let the IRP come.
But then let him serve a copy of this application on the resolution professional.
Unless it has been amended. Or you do one thing, you serve the copy of this.
Let him serve. Let us see what the IRP has.
Have you served?
We've already served. Served a copy as well. Just
have you served?
Yes,
Before addition, it may be let
just served him a notice. I have not said anything. Served him a notice. Nowlin's address, my lord, registered office, I have served, and also by email. You served, right? That is not part. The email is not part of the affidavit of service, but we have a copy of the email. Please, it a email. Reddy is the IRP. That's the person I'm trying to implead. This is a copy of the email. We've also served.
He's not appearing, Malad.
Malad, today I'm on a fundamental. Malad will have a look at the service. I'll make just one submission for Malad's kind consideration.
Yes.
Today the IRP is not a party to this suit. All I am seeking is to incorporate his name into the cause title under section 20 as well as section 25 2B, which my learned friend has indicated. Specifically, it said the IRP is entitled to represent the corporate debtor in suits. The judgment of the Delhi High Court I have referred to, my learned friend perhaps did not have time to read it. Here a counterclaim was instituted against the plaintiff. It was not stayed. The Honorable Delhi High Court goes into the issue and says this will not be an order. Regardless, my lord, I am only seeking an amendment as to the cause title to only bring the resolution professional on record, serve him a notice as to the plaint in full after amendment of the plaint. Thereafter, if he takes out an application for stay, we'll deal with it when it comes. And as to my learned friend's submission as to my filing a claim before the NCLT or under the IBC, that's at my own peril, if at all. And it is also settled law today. Well, there's a catena of decisions of the Honorable Supreme Court where personal guarantees, because a lot of situations arose where the corporate debtor went into insolvency, personal guarantors, who are the directors and other related personnel of the corporate debtor, would come up and say, since the corporate debtor is in insolvency, I cannot be proceeded with.
No, that's a
Supreme Court-
different
no,
aspect
that's
of
exactly.
moratorium of the corporate debtor does not extend to the personal guarantor.
Here,
That has been settled by Supreme Court.
Here also my case is of guarantee. I am invoking the guarantee given by the
No,
defendant.
he has
number one.
already, this is not correct. He has already invoked the guarantee. He applied for judgment upon admission, which was rejected, and the rejection order has been accepted. Now the issue is, I am only whether the resolution, if the resolution professional is brought on record, he cannot discharge his duties. He can only discharge duties as provided in section 25. Had it been a case of liquidation, I would have taken a step back, because 35(1)(k) provides that the liquidator can defend a proceeding against the corporate debtor, but 25 does not provide such. And IBC, in my humble submission, will override the Commercial Codes Act in view of section 238. See, the effect of section 14 read with 25 has to be given a primacy.
Section 14 does not apply in this case. This is not a suit against the defendant number 2, corporate debtor. I have specifically pleaded in my plaint in para 30 that I am seeking no reliefs as against the corporate debtor. The dismissal of my judgment on admission application does not dismiss my suit. I am entitled to the final relief if I can pray for it and prove it in trial. My learned friend knows much better than me that dismissal of a judgment on admission does not prevent a plaintiff from getting a final decree after evidence and after trial. If I succeed on my claim as to a guarantee that has been given by the defendant number 1, I will be allowed to get that decree.
Yes.
Obliged. Will kindly allow the application.
Only one. I will not trouble your lordship with much law. Only on one point, even I have one. The Supreme Court has even said, kindly see 2018 16 SCC 94. Supreme Court has, my learned friend has cited a Delhi High Court. I'll cite a Supreme Court. The effect of moratorium. Yes. Kindly see, para 4 of the judgment. My lordship has taken para 4 of this 2018 Supreme Court. The mandate, this is at page 95 of the report, para 4.
Yes.
The mandate of the new insolvency code is that the moment an insolvency petition is admitted, the moratorium comes into effect under section 14(1)(a), expressly interdicts institution or continuation of pending suits or proceedings against the corporate debtors. So continuation is also prohibited. Now kindly see, this being the case, para 5, this being the case, we are surprised that an arbitration proceeding has been purported to be started after imposition of the said moratorium, and appeals under section 37 of the Arbitration Act are being entertained. Therefore, we set aside the order of the district judge such and such, and further state that the effect of section 14(1)(a) is that the arbitration that has been instituted after the aforesaid moratorium is non-est in law. Section 14 of IBC completely protects the assets of the corporate debtor, because till the time the CIRP is on, it's a protection, it's a blanket protection which is given to the corporate debtor. No proceedings should be initiated. Pending proceedings should not be continued. Here he has cited a Delhi High Court, where this judgment of the Honorable Supreme Court has also not been dealt with.
Yes.
May I respond, one line, 2 lines rather. This is not a suit or proceeding against the corporate debtor. Will kindly take note of my
party.
He's a party.
Yes, he is a party, not against the. Against
If
the
at all the
debtor.
suit, if it's not to proceed, it will not proceed against the defendant number 2.
Why you're not deleting the name?
It cannot be, because it is a stay. What does section 14 say? It says the suit will be stayed as regards the corporate debtor. Stayed. It doesn't imply dismissal of the suit. If afterwards,
I will state the defendant number 2.
Malad can do that. I was only impleading the defendant number 2 and amending the cause title so as to have knowledge of the resolution profession. That is all.
Impleading is different things, sir. Stay of the proceeding.
Of course,
is different.
I bow down. I completely bow down.
You have filed an application for amendment for amending the cause title for representing the defendant number 2 by the resolution professional appointed by the tribunal.
Yes,
correct.
Yes,
now the Supreme Court says, your Delhi judgment says, no, even the 14 too, it may continue.
in the facts and circumstances of that case.
That case. Now here you are the party.
Yes.
Though you are not asked for any relief.
And
You are telling that it is a proper party. It is not a necessary party.
Yes.
Okay.
Yes,
If it is not a, but he is a party.
He is a party.
If
He's
it is a
under-
party, how the court can proceed if it is a moratorium is there?
My lord, I am not seeking for this honorable court. My lord will pass an order of stay as regards the defendant number 2 also. I don't stand in the way. But only for the purpose of proper adjudication, I am seeking only to incorporate the name of the resolution professional into the cause title. I am not even seeking expunging. I am not, and the section 14 does not contemplate expunging. My lord will kindly appreciate. It contemplates stay. A stay of a suit is temporary. Perhaps later on, after a resolution plan is passed and the moratorium is lifted, the suits again come back to life. They can again be proceeded against. Here, there's a distinction. There are two distinctions. Number one, I have specifically pleaded in my plaint and not sought any relief against the defendant number 2. I specifically pleaded. Para 30, my lord, I showed, my lord, page 47. Para 30, my pleading is, I am not seeking any relief against the defendant number 2. I have only implemented him as a proper party. This is not page 47, my lord, will kindly have once. Page 47 once for my own satisfaction. Page 47, para 30. The cause of action of the plaintiff is independent against the defendant number 1 is independent from that of the defendant number 2. The plaintiff is also entitled to separate relief as against the defendant number 2. The plaintiff is not claiming any relief. I am only seeking an amendment as to cause.
Kindly see page 44.
No in the suit.
Page 44. Kindly see from page 43, para 23 of the plaint, a part of his proposed amendments. Page 43 of the application, para 23. Plaintiff is therefore entitled to claim and thus claims the said sum of wrong as the defendant number 1. Now kindly comes to page 44, the last 3 lines of para 23. The obligation of the defendant number 1 to make such payment is direct and or in any event joint and or several and or coextensive with the defendant number 2. So his claim is interlinked with the defendant numbers 1 and 2. He cannot, my lord, after this pleading being indicated in his body of the plaint, my lord, cannot say that his cause of action is on a completely different footing altogether. And kindly see the nature of the transaction.
No, obligation of the defendant number 2.
Yes.
One is to make payment. Not against the plaintiff.
Yes, but kindly see the
obligation of the
defendant number 1 to make such payment is direct
or in any event
joint and or several and or coextensive with the defendant number 2. But defendant number 2 is not a mere spectator so far as the array of parties is concerned. But
I will record his
very well.
I will record his submission.
If he does not, if he stops proceeding against the defendant number 2, all pleadings, all cause of action.
I record his submission.
Very well.
I will record the prayer portion and I will record the second paragraph 32, paragraph 28.
Yes.
Paragraph
30, para 30.
Paragraph 30.
Yes, yes.
My lord, may I also file a supplementary affidavit just because the name of the RP that was not there in the original application. A wrong annexure went in. I'm just filing a supplementary for that.
Well, may I have your lordship's leave?
The plaintiff has filed the present application being GA Com 4 of 2025, praying for amendment of the cause title of the plaint by incorporating the name of the resolution professional, namely, yes, where is the name?
My lord, the name is at page 34, my lord, kindly have.
Namely,
Page 34.
Mr. Malaigi, Maligi, Malaigi Madhusudan Reddy, comma, IIBBI, comma, registration number IB-001/IP-0008/2018/11427, having his office at Reddy and Company, capital, Reddy and Company, comma, 4th floor, HSR Eden, Road number 2, Banjara Hills, Hyderabad, Telangana, pin 50034, outside the jurisdiction of the aforesaid. jurisdiction of the person. Full stop. Counsel for the plaintiff submit that the after filing of the suit, the plaintiff came to know that by an order dated 4th June 2024, the NC and National Company Law Tribunal, Hyderabad bench in CP number 69/9/HDB/2023 has appointed Siri. Where is the
Yes, my lord, that portion is,
That
my lord, at
portion?
page 29 it starts. Page 29, my lord, will kindly have. Initially, this was the IRP
Has
substituted by, yes. I'm sorry.
has appointed Mr. M.M. Reddy.
No, my lord, that's
Mr.
the
Mr. Pankaj Bhattad, BHATTAD, as IRP under section 13 within bracket 1 within bracket small c of the IBC code. Subsequently,
my lord, the supplementary affidavit annexure A, Mr. M.M. Reddy was appointed as RP. After
subsequently by an order dated
order dated
23rd July 2024. Where is the name?
M.M. Reddy. My lord, the last line, new IRP, Mr. Malika.
2024,
Last
Mr. Malaigi Madhusudan Reddy is appointed as IRP in place of Mr. Pankaj Bhattad. IRP instead of Mr. Pankaj Bhattad. Learned counsel for the plaintiff submit that the plaintiff has not prayed for any relief against the defendant number 2 in the plaint, but the defendant plaint against the defendant number 2 in the plaint and the defendant number 2 is not a necessary party but is a proper party to adjudication of the suit filed by the plaintiff, and as such, as the defendant number 2 has gone into CIRP and IRP has been appointed, thus the IRP is to be made as party being the representative of the defendant number 2. Full stop. Mr. Learned counsel appearing, Mr. Haritra Basu, learned advocate appearing for the defendant number 1, submits that the defendant, the resolution professional cannot be made as a party as party being the representative of the defendant number 1 in terms of section defendant number 2 in terms of section 25 of the IBC code 2016, and he relied upon section 25 subclause B of the said code and submits that he has no the resolution submit that the IRP has no authority to defend the suit on behalf of the defendant number 2 before this court. He submits that the plaintiff had the knowledge that the publication was made on 6/6/2024, but the defendant number 2 has not made any claim before the IRP and has not made any claim, and subsequently the learned tribunal has appointed the IRP and during the moratorium the IRP cannot be made as a party to the instant suit being the representative of the defendant number 2. Mr. Learned counsel appearing for the plaintiff has relied upon the judgment in the case of SSMP Industries Limited versus Perkan Perkan Food Process Private Limited, reported in 2019 SCC Online Delhi 9339 and submits that submits that unless the proceedings has been unless the proceeding has the effect of endangering, diminishing, dissipating, or adversely impacting the assets of the corporate debtor, it would not be prohibited under section 14 within bracket 1 within bracket small a of the code. He submits that in the present case also there is in the present case also the plaintiff is not claiming any amount from the any claim against the defendant number 2, and as such there is no bar for making the hierarchy as party being representative of the defendant number 2. Full stop. Then Mr. Basu, an advocate appearing for the defendant number 1, has relied upon the judgment in the case of Alchemist ALCHEMI Assets Construction Company Limited versus Hotel Gudavan Private Limited and others, reported in 2018, volume 16, Supreme Court Cases 1994, and submits that the mandate of the new insolvency code is that the moment an insolvency petition is admitted, moratorium that comes into effect under section 14 within bracket 1 within bracket small a expressly interdicts institution or continuation of the pending suits or proceeding against the corporate debtor. Mr. Basu submits that admittedly in the present case the moratorium has come into effect and IRP has been appointed, and as such the suit cannot be proceeded against the defendant number 2. Heard the learned counsel for the respective parties produce the materials on default. This court finds that the plaintiff has not prayed for any relief against the defendant number 2. Prayer A, which is the consequential prayer in the plaint, reads as follows: semicolon, inverted comma, small a. Decree for rupees 2,01,14,234 against the defendant number 1 in terms of paragraph 25 hereof, inverted comma close. In paragraph 30 of the plaint, the plaintiff has made the following averments. Paragraph 30, quote kori page 47. Full stop. Mr. Basu has draw the attention of this court to the statement made in paragraph 23 of the plaint, made in the last line of the paragraph 23 of the plaint, which reads as follows. Yeah, the obligate page 44, last 3 lines. Full stop. This court find that the plaintiff has not prayed for any relief against the defendant number 2. In paragraph 3, the defendant, and in paragraph 3 also the plaintiff has categorically mentioned that the plaintiff is the cause of action of the plaintiff as against the defendant number 1 is independent from the defendant number 2. The plaintiff is entitled to separate relief as against the defendant number 2. And however, the plaintiff is not claiming any relief against the defendant number 2 in the present suit. Taking into consideration of the said statement and the prayer made by the plaintiff in the plaint, this court is of the view that only the defendant number 2 being a proper party and not a necessary party for adjudication of the suit has made the defendant number 2 as a party. But now the IRP has been appointed and the defendant number 2 is in CIRP. Accordingly, this court find that only for the purpose of adjudication of the case, as the plaintiff is not claiming any relief against the defendant number 2, to 2, comma, the resolution professional can be made as a party to the suit being the representative of the defendant number 2. In view of the above, the proposed amendment as sought for by the defendant number 2 is allowed. Plaintiff is allowed, comma, the department is directed to make necessary amendment, and in terms of the proposed amendment as mentioned by as indicated by the plaintiff in the proposed amendment within a period of 2 weeks from date, full stop. After the amendment is carried out, comma, the plaintiff is directed to re-verify and reaffirm the affidavit within a week thereafter, and to serve the copy of the amended plaint to the defendant number 2 through the IRP. And the IRP has a liberty to appear in the matter to defend the case on behalf of the defendant number 2. GA number so dispose. उससे पहले देखो, the plaintiff had served the copy of this application to the IRP through speed post, through post, no?
Post, as well as email.
Through post to post as well as email, but in spite of the receipt of the notice, the IRP has not appeared in the matter.
Deeply replied.
Yes.
Great. One, my lord, I appear for the plaintiff. My lord, here, my lord, had granted an interim order of injunction. We had filed an application, my lord, for judgment on admission. My lord, would kindly have, my lord's last order of 21st August 2025. The defendant has sought time to file an affidavit in opposition. No affidavit has been served upon my client, my lord.
But nobody today it is not.
My lord, we'll take it up
Not
tomorrow.
today. Not today. Not today.
Item number 53, my lord, I have out an application for recall of an order, but I'll just indicate, my lord need not pass any order.
My lord, item number 52, your lordship, I was appearing, your lordship. Item number 52, my lord. File commercial. My lord, I appear on behalf of the plaintiff. Your lordship will recall GA3 was being heard, my lord. And since it will take some time, my lord will kindly make it not today, your lordship.
I'm in the next item, my lord, 553.
52 already, not today.
Oh, grateful, my lord.
Yes.
In 53, I am for the defendant. I have filed a written statement, my lord. Talks of settlement were going on. It didn't materialize. Thereafter, my lord, the plaintiff's witness had come, my lord. He was examined, and thereafter he was discharged in my absence. And I filed this application for recall of that order, seeking permission to cross-examine the.
File a written statement.
I have already filed my written statement. It is on record, my lord. This is
Like
not
as a 151 application.
in the nature of, my lord, on the basis that I was not there. And in fact, my lord, the affidavit of evidence and the judge's brief, my lord, that has also not been served on me.
It is not undefended, sir.
No, it is not undefended because I filed my written statement.
You're not present on that.
For 2 consecutive
this
days.
court?
By this court, my lord. But since, my lord, the other side is not here today.
Not today.
My lord, we'll come back tomorrow.
Item 54. 54 and 55, my lord.
The arbitration is going on since 2009.
What is going on?
Arbitration.
Arbitration.
Yes. The petition, they are appearing, they are contesting, they are arguing
before the arbitrator.
Before arbitrator.
Yes.
Now in this matter, they have filed an application for stay of suit. Before that, my lord, they have filed.
Who has filed an application for stay of the suit?
My lord, the respondent. My lord,
you are for the.
My lord, I am the defendant here, MSTC.
You are the defendant.
Here, MSTC. When the arbitration, I am for the claimant.
No, now, here you are the defendant number.
I'm the defendant MSTC.
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 Defendant number 1.
Defendant number 1.
Yes, you are the claimant before the arbitrator.
Arbitration.
And CISA International are the private respondent.
Respondent there.
There.
Now, in the suit, I have filed a Section 8 application asking that the should be transferred.
What is the claim here?
The claim,
what is the claim in the suit?
The claim in the suit, the suit they have annexed, not annexed. will also kindly see.
Yes, appointment of arbitrator. Yes.
Yes, my lord.
Where is the prayer portion?
But it is not is they in this application they ask for stay of the arbitration proceedings. You will also kindly see prayer. It's a frivolous application. But in the there are fourth arbitration. My lord, they have filed the earlier. My lord, you will see they have made an allegation against the arbitrator. Arbitrator refused, but against my lord, then that another arbitration was appointed.
Order be passed in the section 8 application filed by the respondent.
B, my lord, kindly see, my lord, the pair B. They are
Stay of the arbitration proceeding.
In the application for appointment of arbitrator, you'll also kindly see this order before Justice Kapoor and Justice Sarkar, but they have appeared, they have not raised any objection. As the arbitration is in the final stage, they are saying that they are trying very here and there to stay the arbitration proceedings. But this application is not maintainable. Also, this is.
But where is the other side?
Well, the last occasion they have also taken time. Today I am from the.
Okay, not today. Come tomorrow. Not today.
But you should kindly make an order then so that I can serve upon them. Because
but to the bar resolution,
as your lordship,
negative
as your lordship,
adverse order.
As your lordship, please. But may I take back the matter?
Yeah, take your. Not today. Order de do.
Both 54 and 55.
54, 55, not today. Huh? Next. How many cases are the skipper?
The people seem to not want to pay our
Skipper is to be skip, but here
they don't seem to be interested in paying our bills. That's the only difficulty.
That's why you're continuing. Yes.
This is that matter relating to the written statement. Malad will recall, Malad had called for a report, written statement not filed after 120 days. Mr. Rituban Shorkar was appearing. I don't stand in the way, Malad. Let him come tomorrow.
Not today. Next.
Lord, item 57, Lord, I appear for the plaintiff.
Who is for the
defendant was appearing. They have even filed the written statement. This is my application, Lord, under order 13.
Order?
Order 13 for summary judgment, because before the filing of the suit as well as during pendency of the suit, the parties have sat. There are minutes where they have said they would pay the entire amount in installment. Everything is recorded. But despite that, their obligation was to start in April 2025. The installment, despite recording everything, there is no payment forthcoming from there. So this is my order 13, and in aid of that, the final relief, we are also paying for an injunction.
Yes.
So, I understand because of the resolution we cannot do anything, but could it appear tomorrow, my lord?
Not today. Next. Not today.
9, Your Lordship, I appear on behalf of the defendant number 2, my application for acceptance of written statement.
Who is for the
appear for defendant number 3.
Plaintiff? Within 120 days?
My submission is it's within 120 days, but I'll be candid on the last occasion, Lordship. The plaintiff was objecting that it is not within 120 days. So, Lordship, I think it will be better if it
not today. Not today.
Application, Millard, item 61. Millard, I am for the bank, Millard. 12-way revocation has been filed, so I couldn't move the injunction. Last day time was sought for, Millard. Also, this problem happened. Dues are, Millard, 30,000 crores, Millard. So I have to place, Millard. They are not debtors, not guarantors. Some family members, shares have been transferred. So I need some protection. I leave it to your Lordship. Any date, Lordship gives me. Tomorrow may not be, Millard. Lordship has other determination. Any date, Lordship gives me. Thursday, Friday, whenever I am here, Millard. If they want
Who is for the other side?
Other side, Mr. Shubhranil Millard was, and Mr. Shoroshish Dasgupta was appearing, Millard. And I think they have been led by Mr. Tilak Bose.
Led by?
Mr. Tilak Bose. I am led by Mr. Joy Shaha, Millard. He mentioned the matter also, Millard.
Correct, date 16, na? You are for the plaintiff.
I am for the plaintiff. I am led by Mr. Joy Shaha.
Then counsel for the plaintiff is present.
Aditya Mondal.
None appears on behalf of the defendant. Let the matter appear on 16 September at 3 p.m.
Grateful. Grateful. Much of that. They have to press the 12-way first, Millard. I'll respond immediately. Grateful.
12A on the what ground? Not urgency. No urgency.
No urgency, my lord, they say so.
Yes,
Great.
next.
62.
Not today. Not today.
63 Milad, 63 Milad. I am appearing on behalf of the petitioner. This is coming up for the first time. It is my application for injunction. Suit is Milad for recovery of money for services rendered by a lawyer. The Lordship Milad was pleased to accept the presentation. But since there is nobody today, Lordship can keep it tomorrow.
Not today.
We have effected service. We'll move
Not
the
today.
application.
Malad, the substitution application where Mr. Bose was making his submission.
Have completed. I have nothing more to add.
My substitution application so far as well as the partnership concern.
That one?
Yes, ma'am.
Not today.
Yeah, Your Lordship, item number 55 I am appearing on behalf of the petitioner. I am paying for not today.
I'm reading him.
I'll answer the next day in presence of Mr. 66, Mr. Gupta, I was making my submission. Very well, you come back next day. I'll make
No, sir, if you're ready, you can. I would say that I would give the reply on someone.
Not today. Not today.
No one is
In which matter? Any both the parties are there? Any matter?
grateful.
Both the parties are there, then I will take the matter. Otherwise, let it go. Is in any matter both the parties are ready? Then the matters can be taken off. Otherwise,
3 p.m. matter, my lord.
yes. Yes, yes. You will.
Mr. Shiv Shankar Banerjee was addressing your lordship. It may come back to my lord. He went to great lengths to support his national
That
issue.
one. Yes, yes.
On the last day, he said that he would cite one more judgment. In fact, there is an order recorded to that effect, Judge Sahib ke din. The copy is not here today. The judgment can't be cited. It has not even been forwarded to us.
Not forwarded?
No. In any event, they are not here today, my lord. Well, kindly fix a date, my lord, because the point is very small, as your lordship remembers. Your lordship has been very kind so as not to stop him. I should be very brief, my lord. I will not take more than half an hour.
कोई डेट है क्या होगा? Twenty 22nd 3:45. Though the matter is fixed today, especially fixed today at 3 p.m., but due to bar resolution, the land counsel for the defendant is not present. Accordingly, case is adjourned. Let the matter appear on 22nd September 2025 at 3:45.
Very grateful. Order to the other.
My lord, just